in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her at night. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's been tight as a vice. In this endless trial, we pay the price.
Hello, folks. It is Friday, and it's time for a Friday panel show where we go through some of the things that happened this week in the Young Thug trial. Specifically today, we should have tons of replies from the prosecution. We already passed end of business today, and we haven't gotten a whole lot from the state, so probably the state filed it at 5:59:59, and then it takes time for the clerk to upload it. We have for you, let's see here. State's response: assuming facts not in evidence. State's response: adopted admissions. State's response: self-serving hearsay. State response: vague questions. Opposition to state's motion to restrict extrajudicial statements. And you heard the four first. The state responding to old motions from when Judge Glanville was still on. And between their filing of their motions and now, Mr. Steele filed a reply. So we have 6 motions to go through with you, but other things as well, because it's Friday. Not entirely serious today. So a few people that will help me be with that is I have Dave here.
Hello. You know, I was old when this, or young when this trial started too. I like that intro, by the way. Yeah. You know, I miss Judge Glanville. That's all I'm going to say about this.
Oh, yeah. This will be a completely different trial moving forward with Judge Whitaker.
It will. So I don't know where you're going. I just had a question. They didn't do any arguments. This is just the filing deadline today, right?
Filing deadline was today. Okay. The hearing starts Tuesday.
Okay.
So then they will talk about it. And yeah, this will be, I can't wait. I made sure that I can leave work early on Tuesday, because when the Judge Whitaker says 8:45, she means 8:45. She even told the lawyers, when I say start time 8:45, I mean 8:45. That, which in my opinion was quite a big shade on Judge Glanville's inability to get people there on time and himself being on time.
I was just thinking about everything going on my Tuesday and wondering if I can move stuff around so I can watch this disaster of a trial, but I'm going to have to jump in and out and then catch up on it later. Josie Guzman says in the chat, Glanville needs a reality TV show. It would be an amazing reality TV show. I mean, he'd be a locale for sure. Everyone would be laughing at him and not with him, but it would be an amazing show.
Yeah. And speaking of laughing at or with, we have Dali.
Thank you. How are you doing?
I'm doing okay. It's Friday. I'm having a beer.
There you go.
Nice. Oh, someone asked, Ghost asked about this. Says my favorite sister bought me this shirt. And the sister would be Feral Housewife. If any of y'all know her in the chat.
Oh,
that goes way back. That goes way back to her living in my attic.
That was
that one.
That one. That was so good.
That one, yeah.
Oh, I missed that guy.
Yes,
He's probably out of jail by now.
And just factual, I have seen it. We will get to it. We will get to it. I actually haven't read that one because that just dropped. Oh, what a week!
So okay, so if I'm remembering correctly, when the new judge took over and had the status conference, she said, first of all, you guys are going to exchange witness list. You're going to name all the remaining witnesses and what evidence you're going to introduce to these witnesses and what you expect them to testify to.
Yeah.
And then if there's any outstanding motions regarding those witnesses or the evidence or anything else that already hasn't been ruled on by Judge Glanville, then you file your motions and we will take it up. Right?
Yeah.
So was there a witness list filed or was it just exchanged? Do we know anything about the witness list and exhibits?
Well, this is about the state. Their witness list has about 130 more people. And they have waited until the Friday before the week of the expected witness to share with the defense what evidence they plan to use with that specific witness. And with Judge Glanville, when at times, quite often, the defense says, we didn't know this piece of evidence was going to be used because we have 7 terabytes of evidence. And if the state says we plan to use jailhouse calls, they have 7,000 jailhouse calls listed in discovery. And Judge Glanville just ignored that. Well, you have access to it. So more or less, the Friday before a witness entered the stand on Monday, they got this, we are going to use these 5 jailhouse calls, for example. And then the prosecution renamed the jailhouse calls from what they were named in discovery.
Well, okay. So let me just, I don't want to defend the state too much here. But when we're in discovery, I might send the other side a whole bunch of documents. I might list them. I might identify them. I might bait codes them. I might not. Might even page number them. I might not. I send them a whole bunch of stuff. But then usually a couple of weeks before the trial, typically in Michigan, it'd be 14 days, we're required to produce like a final exhibit list, right? And what I typically do is I also share the exhibits. And so I'll go through and I'll say exhibit 1, email dated such and such. And then I'll identify that at the bottom of the page as exhibit 1, exhibit 2, whatever. So the names might be completely different in the final version that I send over. And then I usually bring a binder with granted, it's not this big of a trial, right? But I usually bring a binder for both the court and the other side, whether it be the plaintiff, defendant, prosecutor, whatever. And then I have my own working copy of the exact same things. And they could be labeled completely different than what they were originally sent out as. And so I will give the state a little bit of credit on that one, but it sounds like a bunch of BS.
Yeah. For example, the last witness, Woody, when the trial was put on a halt, they were in the middle of the jailhouse calls and the interviews. They were at that when Woody took the stand. Then the prosecution shared with the defense, we want to use these 15 hours of police interviews. That's not uncommon. And these jailhouse calls. And in the middle of Woody taking the stand, well, all this debacle happened, but they were having hearings about, because the defense had objections about certain parts, because it's hearsay upon hearsay, it is unknown speaker in this jailhouse call. that shouldn't be. So there was in the middle of, since the state didn't produce, we are using this for these reasons with this witness, even though you could probably say, okay, these are amongst, these is the evidence they plan to use among these, but the defense had this. And in the middle of testimony.
Do we know if there were any pretrial motions filed asking for a specific list of exhibits that the state intend? Like, did the defense file a motion and say, Judge, we need a specific list of exhibits and what portions of the recordings that the state intends to use? They did do that?
Yeah, and the judge punted it forward. We will do it when timely.
I have a dog in my garage.
Congratulations, Dave. You have a dog.
I don't know what that was. That was weird. I'm in my shop and there's like people coming and going, and all of a sudden there was like a dog barking. I don't know what's going on. It's just my house.
Yeah.
The only reason I say that is I've been trying to think, and I'm not trying to give Judge Glanville or Love any sort of credit here whatsoever. I'm just trying to imagine in my mind, if I was the judge, the presiding judge, how would I do this? And I would basically say, listen, on this certain deadline, you have to have all of your evidence exchanged. And then on this deadline, you have to have a final list of your exhibits exchanged, along with what portion of the recording, whatever you plan on using. And then if anyone has any objections, we file all the pretrial motions. But once the trial starts, we're locked into that evidence, understanding that there's the possibility of rebuttal evidence and things like that. But you want to be locked in. A trial is not an exploratory proceeding, right? It's a scripted event. You know the parties, you know the witnesses, you know roughly what they're going to testify to, you know the exhibits, all of that in advance. This isn't trial by experimentation. So stupid to do it like piecemeal as you come.
Yeah, I mean, and the state filed with the court in November of 2022. We are ready for trial. They had 70-something witnesses. Up until the start of the trial, the trial part of the trial, during what you call it, Daubert hearings and jury selection that took 11 months, that list grew to over 700 witnesses. Then the judge made them cut down, so they only had 400 witnesses. And then 3 months into the trial, the judge made them cut it down to the 209 witnesses. To 209 witnesses. So that was mid-trial. And after that, the judge told the prosecution that you need to show to the defense the evidence you want in the Friday before the week you intend to call that witness. The evidence you plan to use with that witness.
These charges were pending since 2020, right?
They were arrested in May of 2022.
Oh, 2022. Okay. So we're 2 years down the line. We don't have the all the defendants are still in lockup. We need to get this trial started. So the judge might be thinking, Judge Glanville might be thinking, we need to start this trial. We will take care of the evidentiary rulings as they come because we need to get this trial going. But I think he put himself in that position by not properly managing the pretrial proceedings. I can understand that there would be pressure on him to get this trial going, but he put himself there, and you can't just shortcut the whole thing because you screwed up.
I completely agree. Hello, and hello, folks in the chat, both here and over at Rumble. So streaming on Rumble today, folks.
Nice. Eric Ross says he thinks the judge and the DA were plotting against the defendant. LOL. I don't think the judge was plotting with the DA. I think the judge didn't give a shit. He just wanted to get through this trial. Guilty, acquitted, whatever. He just wanted to get through this trial and be done with it and move on to the next one. And that's the problem, is I don't think he cared.
Well, he cared enough to, for instance, with the ex parte meeting, to initially refuse to release the transcript. He said, well, that's for the appellate court to decide if I did right or wrong. So he didn't plan to release the transcript until after the conclusion of this trial, of this ex parte meeting. And so far he has refused to give, up until he was deeded, he refused to give certificate so that they could appeal certain decision and rulings.
You want to see the text message I just got? She says she's running for president.
Oh,
That's
okay.
nice.
Why do you got to send a picture?
Mm.
I mean, I know the name. I'm running for
Dave, have you
president.
heard? There are talks about Miss Harris as a running mate, that a certain Gretchen Whitmer might be in contention of being vice president.
Fingers crossed. Fingers crossed. It's a win-win for me. Either Trump wins or Whitmer is out of Michigan and on to DC. Either way.
All right, but we are here for the Young Thug trial. We are waiting for Miss Cat, not Williams, because she said she would show up eventually.
Yeah, I like her. I only met her. Was it last week? I jumped on for a minute.
Yeah.
That's the first time I had met her. I'd been in her chat quite a bit, actually, watching her stuff. But she has way more time on her hands than I do to be up to speed on some of these things.
Yeah.
But just we could talk behind her back real quick. What do we know? She's not an attorney. Do we know what she does? She just stream full time, or
No, she has a job. I think she works. I think some in the legal field.
Okay.
I'm not sure. I must admit, I'm not sure.
Well, I'm good. I'm just gonna ask her.
Oh,
Yeah, good. That's a good. That's good.
what could go wrong?
I was up Mackinac Island last weekend for the race, and there's a woman who sails with my wife, and she acts very young, but she looks kind of older. And so I just came out and yelled at her how old she was, asked her how old she was. Everyone's like, you can't ask her that. I'm like, why? I want to know. She acts very young, but she looks a little older. Some people age differently, right? So I just like asking people questions. She said she was going to stop in. Okay, Christine says she was going to stop in.
Yeah. Okay.
David's wife's friend or someone else?
Kate, not Williams.
Oh, okay.
Now, this is the first reply.
No, you can't date her, Sal. You can't date her.
You can't save her. This is the first reply. And this left me a bit. I don't remember Mr. Steele filing this last week or this week. But this is
today.
a reply in response of opposition to defendant's motion for correct ruling on assuming facts not in evidence. This motion from Mr. Steele is months old. But Judge Glanville punted it forward and didn't make a ruling on it.
Oh, yeah, because the judge was clear. If there's outstanding motions or motions you haven't brought yet, you bring them now. And so the state's probably thinking, I need to file a written response to this now, or else I'm going to lose the opportunity. Because this judge means business.
Yeah, so that means, for the last 2 months before the trial halted, there's something in the motions. You have several motions of mistrial and several motions of reconsideration. It's in the 20s, I think, that was still outstanding, that Judge Glanville still hadn't ruled upon. And I'm expecting, we are over the deadline for replies. It was before business today. So it will be interesting to see what is stopping by, because I do have access. So I have to some of them, but two of the file we are reading through today somewhat. is 2 of them are from the defense and only 4 from the state.
This is written so weird. Oh my God. So on June 10, 2024, defendant Williams moved this court to vacate proper rulings on state's objections, precluding cross-examination questions, which assume facts not in evidence. Oh my God. Okay. That's a horribly worded sentence, but essentially the defendant asked a question, the state objected and saying facts were not in evidence, and it was sustained.
Yes.
And so now the defendant has moved to set aside that sustaining objection. That's what it sounds like. And now she's responding. Oh my God. But that's a horribly worded question.
Yeah. And that it should be denied, and then argument and citation of rule of evidence, blah, blah, blah. Courts are mandated. And
wait, Steele filed at 5:30, 259 pages. Start reading at page 72. Oh my God. Okay.
Yeah. Because he answers all of these 4 state replies to his motions. So the state so far have only replied to Brian Steele's motions from months ago. Let's see, where was it?
You know what? Based on No Sir San's comment, I do want to say he said actually serendipity that Granville's pandering to the prosecutor actually caused her more work. Thanks to his sort of fly by the seat of his pants sort of approach to this trial, it's actually preserved a lot of legal issues that the defense can now bring. Because as a standard rule, a judge is not going to overturn another in a parallel judge's prior order. You have to go to the Court of Appeals for that. So because Judge Glanville decided not to rule on these things, he's actually preserved it for the benefit of the defense.
Yeah. And this is the question that was objected to and sustained. They asked Detective Belknap, whatever. Do you realize that in Fulton County and in our country, the only artist lyrics that have ever been prosecuted in a criminal case are rap lyrics? Now, Detective Belknap is both a layman witness and an expert witness, according to the state. So they have used him as both. They start out as asking him questions as a layman witness, and then they told the judge, now we want to start asking him questions as an expert witness in the middle of his testimony. I've never heard of that.
Wait, he was proffered as an expert?
Yes.
Okay, so he's proffered and certified as an expert by the court, right? On direct examination?
Yeah.
So on cross-examination, the question is, do you realize that Fulton County and in our country, which is kind of a weird way to say it, the only artist lyrics that have ever been prosecuted in a criminal case are rap lyrics?
Yeah.
Well, why would he not be able to offer his opinion on that? Also, it's not assuming facts, not in evidence. I mean, you could lay foundation for it. You know, have you ever heard of song lyrics being used in a criminal case to attempt to prosecute the songwriter or the rapper or the singer or whatever? Okay, so you establish a foundation real quick and then move on. I don't see why that was so. I mean, it was a poorly worded question, maybe.
Yeah. And Kat is here. Hey.
Hello.
Hey.
Hi, guys.
We are just starting to skim through the state's replies to old Brian Steele motions. And
I was like, this is June and this should have been in on Tuesday, but whatever.
Yeah. And well, the state had up until today, end of business day, which was half an hour ago, for their replies to the defense motions. But we said that a few minutes ago. Judge Glanville punting it forward all the time, not making rulings on these motions. Yeah. Now the state has to reply to them.
Oh, yep.
And it's actually a benefit of the defense at the end of the day. Now, granted, he didn't see that he was going to get kicked off the case, but it actually preserved a lot of these legal issues for a new judge to look at without having to go to the Court of Appeals. He actually saved the defense as much as he's a horrible judge, at least in this particular case. He's actually benefited the defense by getting another second eye on these issues.
Now, Detective Belknap, I don't remember. I do believe when this question was posed to him, he was proffered as an expert witness because he was both a layman witness and an expert witness. And the judge somehow found that, yeah, that's proper. And then they switched mid-testimony with Detective Belknap. Now we have a question for him as an expert. And then it was cross-examination, and Brian Steele asked this question to this witness, and it was objected to and sustained. And it's so weird. I do believe there was another.
Kate, were you listening to the stream before you jumped on?
No, I just got here.
Okay, good. What do you do for a living?
Like
awkward.
Marketing is like the broadest way to put it. It's in the real estate space, like probate, real estate, estate planning.
She works for Zillow, everybody. She puts those fake numbers up.
No, I actually do the opposite. My big client right now.
Redfin.
My big client right now, our agents are canceling their Zillow subscriptions, so it's good stuff.
So you have work.
Yeah.
We weren't talking about you at all or anything.
No, nothing.
That's okay.
God, can you believe that cat?
Now, the other question here, Defendant Williams asked Special Agent Razzie. I don't remember that guy. If he knew that Dolly was in a relationship with Jimmy Winfrey in 2015. State objective because there has been no evidence that the two of them were in a relationship in 2015. But Special Agent Razzie, he was a layman witness. This might be properly objected to if he didn't have any information, but you can always ask, do you have information?
Oh, they actually cite the day on YouTube.
They're using timestamps better now, too.
Yeah. Day 30? Jesus Christ, that was a long... Day 30, that was in...
2010.
Yeah. Day 30 of this trial must have been in early February.
I was still in diapers day 30.
Yeah, I didn't have a beard on day 30. I mean,
you were 23, but
yeah. Well, I had my first beard at 14.
Of course you did. I can see that. One of those weird kids in school.
Yeah. I was a. Yeah.
Maybe one day I'll show my freshman year photo. So, okay. So she's filing this motion or this response rather now. But the judge's ruling at the time was to sustain it. He wasn't allowed to go into those questions.
Yeah.
So here's the issue though. So say this judge rules that sustaining the objection was in fact improper, and that the defense should be allowed to go into this. Procedurally, how I think this defense would have to call this witness during their case in chief, or which would mean that they would be doing it on direct. That would be very weird procedurally how you would address this.
Yeah, because you can't really, back up the trial months. That they are having issues with the trial being backed up 4 or 5 days. Imagine months because they weren't allowed to ask questions. Then you have state's response in opposition to defendant's motion for correct ruling on adoptive admissions. Despite binding Georgia and persuasive federal precedent authorizing their admission on July 10th, 2024, defendant Millions moved this court to vacate prior rulings on the introduction of adoptive admissions. And this is a line they copy-paste all the time. Defendant Williams does not request specific relief on this matter, nor does Williams delineate why this court should eschew binding and persuasive statutory and case law. Blah, 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 blah.
Wait, state's response. Oh, hang on, I'm sorry. A state's response in opposition to what?
Defendant's motion for correct ruling on adoptive admissions.
So the context here is there was a short motion filed by Brian Steele originally on June 10th, but he made an amended version. He corrected it or something on July 7th. But it's really short. And each of these 4 responses is addressing one of the arguments in that single motion. The motion is about Glanville's pattern of sustaining objections. But they give these individual responses saying there isn't that one objection was fine. So that's kind of like the broader picture of it.
Now I get it. They are splitting it up just in case Judge Whittaker says
on
this
one
ruling
issue or
was
another.
bad, this ruling was bad.
That's why it's so repetitious in the beginning.
Oh, wow.
That makes more sense. And that creates even more of an issue depending on how the judge rules.
Yeah.
She's streamlined. She seems to like efficiency.
Yeah.
She does. But then, okay, so let's assume 3 of the objections on 3 of the witnesses are overturned by this judge. Oh my God, what a disaster of trying to recall these witnesses. You would essentially have to force the state to recall these witnesses so the defense could cross them on a overruled objection. Oh, she's probably not
How
going
would that
to.
work?
To be fair, she's not going to. She's going to say, if anything, she's going to say, you can call these people in your case in chief, and then you can question them about these things, but I'm not going to call them back to the stand.
Would they be able to lead?
Yeah, she would probably make a ruling that they would be
Okay.
What is it called? Yeah, and lead the witnesses.
Hostile
Oh my God,
witness.
what a nightmare. Hostile witness, thank you.
See, I know something.
Let's see here. Dun, dun, dun. I'm just skimming through this because I want to get to Doug Weinstein's. I already made a video on it. Doug Weinstein's reply to Prosecutor Love trying to eradicate Jack Goddy's right to free speech by quoting Churchill and Fani Willis. I mean, Churchill is such a quotable person. Almost everything he did in his political career is quotable.
And evaluating whether evidence as the defendant's adopted. Okay, so they're trying to say that in that particular argument that a statement by another defendant is being adopted by all the defendants. Is that what they're trying to say?
I think this goes to a particular piece of evidence being let in, if I remember correctly.
Okay,
The jury is then responsible for making the ultimate determination of whether the defendant adopted the statement as true. This is one of the second-hand hearsay that Judge Glanville let in, I assume.
Yeah. We do this a lot in family law when it comes to husband and wife engaging in commerce and things like that. You know, if the other spouse knew about the transaction and would have had an opportunity to speak up and object to it, but didn't, things like that.
Defendant Williams is partially correct in asserting that mere silence by a party opponent in the presence of another's statement standing alone does not automatically equate to an adoptive admission. However, a defendant's silence may in certain circumstances communicate that he had adopted another person's statements as true, make that statement admissible under Rule 801. Oh, now I have to search my files here. If I remember correctly, the statement was in, I believe it was a jailhouse call with, if it wasn't, I don't remember who it wasn't Woody, it was one of the other plea dealers. It was a statement by somebody on that phone call, and that the witness on the stand didn't reply to it. And a defendant's silence in certain circumstances. So
that bothers me, because if you're like, how would you, if you're silent on a jail call that you think is being recorded? This is speaking vaguely, not in the context of this specific example. But if you don't want to say something incriminating on a call that's being recorded, and then you're silent, then that becomes a catch-22. You lose your right against self-incrimination. Like, it just...
It depends on who you're talking to in reality. So it depends on who you're talking to. If you're invoking your Fifth Amendment right to remain silent, because silence sometimes can be used against you depending on who you're talking to. So I don't know the context of the phone call, though, anymore.
Yeah, this was a good while ago. I don't remember the exact... Like there's so many. I mean, several of these jailhouse calls we've been listening to that was admitted into evidence.
For example, say you're on a party line with 3 co-conspirators. There's 4 of you total, and they're all talking about how they're going to rob a bank and they're going to do this and they're going to do that, and you don't say anything, and then later on everyone's charged and they say, listen, you were part of the conversation, you didn't object to anything, you went along with it, and in fact you shared in the proceeds after they were done doing it. Your silence there can be used against you. That's sort of the idea here.
Yeah, but in this case there is the witness on the stand, who is a plea dealer, was in a jailhouse call with a person, and the third party in that, an undisclosed third party, because that party wasn't named, made a statement.
Oh, I remember this. Yeah.
Yeah. And then the witness was silent. And I mean, this is, first of all, it's second-hand hearsay. You completely against the confrontation clause. And who knows? I don't remember who was on the stand, but he might have just pressed or just taken the phone off his ear, doing this and talking to somebody. That silence doesn't show anything.
Well, that's the thing. Yeah, that in that particular case, we don't even have evidence that he was actually listening in.
Yeah, it's a Foster clock. Now let's see here. Self-serving hearsay.
There are, each document has, one example that's different in each of it. The beginning is mostly the same. Then it gives some case law that applies to the specific thing we're talking about. But then they'll usually talk about, one particular objection, as if there was only one time it was an issue.
Yeah. They're trying to separate it. Instead of looking at the whole picture, they're trying to separate it as separate instances, just in case the judge ruled this was wrong. Because if they have everything and half of the examples are wrong, then the motion can be granted in whole. Let's see here. Wait a minute. What the freak is going on here? Introduction, argument.
But I love trying to do this. She's essentially forcing the defendant to take the stand to say that he didn't adopt that, he wasn't there, he wasn't listening. And I hate stuff that makes the defendant have to take the stand.
Self-serving hearsay is when Attorney Steele wanted to admit the because this is about lyrics. Because if I remember correctly, Miss Love read the lyrics with her own emphasis and everything to a witness. Attorney Steele wanted to play the video when this song was performed, to put it into context, to have the rule of completeness. And this was self-serving or self-quotation or inadmissible. But the the lyrics was already in this case. Mr. Steele wanted to show the performance of Mr. Williams, Young Thug, to the jury, so they could put it into a better context and as a rule of completeness. But it was
Denied.
it was during cross-examination. There was an objection, and the objection was sustained. So that video has not been played, which also is one of these weird things. Why wouldn't the performance be allowed in when they had the prosecutor reading the lyrics? It's so weird.
That's actually an interesting legal argument, and I'm not sure where I would come down on that argument. Because it's an out-of-court statement, right? And so let's assume it's offered for the truth of the matter asserted. If you are a party opponent, you can admit it. So the state can admit it. But if you are the party, then it's not an out-of-court statement offered by a party opponent. So you don't get the party opponent exception. It's not a regularly recorded record as part of a business transaction. I think the best argument would be is that it's not offered for the truth of the matter asserted, because the truth of the matter asserted has already been established, and those are the lyrics. It's effect on the listener, and I think under effect on the listener, maybe you can get it in. It's an interesting argument, though.
Yeah, but see, the lyrics are already in evidence.
Right, so you don't need it to prove the truth of the matter asserted.
Yeah.
And so if you want to, so essentially what you're arguing then is more of a relevancy issue. Is it relevant? Is it duplicative? Is it wasting needless time? Is it relevant otherwise? And you can argue, as I think they're arguing here, that it's putting it into context. It's the rule of completeness. And on those grounds, it should be admitted.
But it wasn't. Oh, okay. And then response: in opposition for correct ruling on vague questions. Mr. Steele. Now, Mr. Steele he does this wonderfully. He asks questions to get the words listened to by the jury, and then he rephrases slightly until he gets the question not to get the question in properly. He does that all the time. So that's very annoying for the prosecution, because he asks the question quite vague, and then he rephrases a few times, and then the question may or may not be allowed to be asked. And the prosecution objects, as they should. And in many cases, I must say that it is a proper objection that should be sustained. But at other occasions, there weren't really vague questions. They were rephrased into less vague.
Can you give me, I mean, I'm sure you can't give me an example of specifics, but sometimes I like that style when you ask a question that you know is going to get objected to because you want the question out there. Mm-hmm. And then, so the jury's already thinking of this improper question. When you rephrase it and ask it a little bit more specific, and if there's another objection, then you can get the state, the jury thinking, oh, what's the state hiding? And then you ask a very specific question that could even be completely irrelevant to the first two. But the jury's already thinking, well, what's the state hiding? And I've already got that thought in my head.
Yeah.
I like that style, actually.
Yeah, so this is just that generality. So, this is, let's see if I will update to see. No, nothing yet. Now, this. Oh, I like this. This is Doug Weinstein. You have seen him on my show on a few occasions. He's a beast in this reply. Oh, this is good. Kendrick's opposition to state's motion to restrict extrajudicial statements.
Hang on, real quick. Can we get some clarification as to when these documents were filed? I think some people in chat are asking.
Okay.
I just privated you Steele's 530 filing from just like an hour ago.
But when were these filed, these documents that we're going over?
These were all today, earlier today.
Oh, yeah, these are all today. It says 5:29 p.m., but this is modified. So this was...
No, that might be it, because Steele is opposing the motion to restrict extrajudicial statements
No.
also.
Okay.
So he's doing that, and he's adjoining the mistrials with prejudice and does not want to be part of Bruce Harvey's motion for a mistrial if there's not double jeopardy attached. So that's not it. But I private chatted the Google Drive link. If you go to the private chat, it's the new Steele motion.
So his motion is only 13 pages, but there's 259 pages. The remainder is exhibits.
Yeah,
most
transcripts.
of it's transcripts. Oh my God, these transcripts are going to be amazing to read.
Yeah. But I want to go through this because I think this is amazing. Comes now defendant DeMonte Kendrick in the above-styled case in opposition of the state's motion to restrict extrajudicial statements, showing the court the following. Everyone is, quote, everyone is in favor of free speech. Hardly a day passes without it being extolled. But some people's idea of it is that they are free to say what they like. But if anyone says anything back, that is an outrage. Sir Winston Churchill. Winston Churchill is so quotable. I joked with Doug earlier today. I can see Doug and Miss Love reenacting one of Winston Churchill quotes. As in, Miss Love says, "If I was your wife, I would poison your tea." And Doug Weinstein replies, "If I was your husband, I would drink it." That, definitely, by the way, folks, was said in Parliament in the I believe 1948 or 49 by a member of the opposition, a female member of the opposition, and Sir Winston Churchill, who was the prime minister at the time. Another, this is such a good one. He was called a fat something by a party of by a member of the opposition, and he replied, "Well, you're stupid. I can lose weight." So Winston Churchill. And the next quote. "I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then get to decide to brag on it. We should do that for a form of intimidation and to further the game and to not be held responsible. Honorable Fannie Willis, Fulton County District Attorney, press conference, August 29, 2022. Free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney." This first few paragraphs, Doug Weinstein, you beast, showing the hypocrisy. Because Doug has been on my show and other shows. Sean has been on shows. Who else has been on shows? Have Steele been out in the news? Well, maybe. I mean, people have been out in the news from the defense. And this is because, let's see, where is it?
Well, no, Q just posed an interesting question that got me thinking. Should we do away with the hearsay rule in general?
I want to get rid of the exceptions. A lot of the exceptions. They should do a complete overhaul of the hearsay rules because there are so many ridiculous exceptions. You have that.
But the exceptions all help the state. If we got rid of the hearsay rule, then the defense would be allowed to use a lot of hearsay statements, and maybe you just go to the weight and credibility as opposed to the admissibility.
I want an overhaul about many of the exceptions, of which you have seen a lot of in this trial, when Judge Glanville is bending over backwards and forwards and on all fours in getting in the prosecution's evidence. You have the jailhouse calls where the third unknown party makes a statement which is clearly hearsay, which is clearly against the confrontation clause, but it still got in on the effect on listener because they didn't reply, which goes to their admission of the statement because they were silent. I mean, you really have to bend over backwards to get that piece of information in. And it's, ugh. But here's from Justice Kennedy. This is a good quote. Attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. So I believe, well, the state's motion to remove free speech from the defendants, that should be thrown out on its head.
I can't believe that she didn't even try to constrain it to what specifically she was wanting to be silenced.
No.
I mean, it's just so audacious to, silence it all.
And she cherry picks parts of the code of conduct rules. And it's amazingly stupid, in my opinion, from the prosecution. But she has to. No, actually, she doesn't. I think
that one she could have left alone. Like she now has to address those kind of broad stroke standing rulings. Like I get that, but she didn't have to. That was personal. I think she took personal offense that people were doing interviews and she wanted to make a motion about it.
And I'm still bummed out that I wasn't entered as an exhibit because I had Doug on my show several times. You have had people on, Kat. I mean, why weren't we exhibits? I want to be exposed. No.
I want the shout out in a document.
Yeah, I want the shout out in a document, in a legal document. I bet infamous Sylvia, she got a good number of views thanks to that motion. I mean,
especially since they put actual links this time. Like, wasn't one of the prior motions they said like YouTube stream with law and crime, and there was no link or URL. It was just like, cool, great citation.
Yeah,
I think that happened in the motion for new trial for Hannah Gutierrez raid 2.
Like
they just go to YouTube.
Like...
just go to YouTube and search this.
So wait, this is a Jason Bowles. This is a Jason Bowles thing. Yeah, of course.
Yeah, who would have guessed it?
Let's
can you imagine Jason Bowles arguing against Adrian Love, like the slow talking Jason Bowles versus the very energetic Adrian Love?
They would never stop talking over each other. It would be a constant white noise of mumbo jumbo. According to the Cromley case, the FBI has listed Valhalla as a hate word. Now, since I'm going to Atlanta in August, I'm quite happy I'm not as an exhibit because I have had words about Miss Love. I have had some strong words about Miss Love. But that is due to the Sean case, where the boy who died in Fulton County Jail. I mean,
well, that's good because we're going to see some arguments about this jail condition in here a little bit, I think.
Good.
Yeah.
Like, rub it in every time. Bring all the awareness to it by any means necessary.
I mean, wasn't it recently that they were about to begin renovations of Fulton County Jail, but they concluded it will be cheaper to build an entirely new jail.
Well, then they can award a contract to somebody for more money.
to their friend
Is it-
Yeah.
for a nice kickback,
Mm-hmm.
and about 50% more than it actually costs. I'm not cynical.
That's what I would bet.
I'm not cynical at all.
Okay, now we get to the latest filing. Mr. Williams' response to the state's motion to restrict extrajudicial statements, motion to adopt motion for fair and constitutional trial on behalf of Mr. Stilwell, as well as the Monte Cristo's motion for mistrial, both filed on or about July 23rd. Notice of non-joinder of Mr. Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge file. Yeah, I like that motion from Bruce Harvey. It was so well written. It was so well. I just had to read it. There was no need to explain. He really dumbed it down to my level. I mean,
Glanville's level.
Yeah, no, he didn't use crayons.
Oh, okay.
What was it? Page 72?
Yeah, I think that's what he said earlier.
Dun, 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 dun. Sorry for the blinking.
It's okay. Hopefully nobody's epileptic.
But we are down to exhibits on page 72. This is just the exhibits.
Oh,
Something
geez.
specific on 72?
No, this is about...
I said start at 72, I thought.
This is about motion to disqualify. This is just an exhibit. Let's go up again. Yep. It's easier to go up than down. Comes now, Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this response to state's motion to restrict extrajudicial statements, filed on July 23rd. Motion to adopt motion for fair and constitutional trial on behalf of Mr. Stilwell, as well as the Monte Cristo's motion for mistrial, both filed on or about July 23rd. And 3, notice of non-joinder of Mr. Nichols' motion for mistrial and objection to mid-trial. Mr. Williams is innocent of all crimes in the above referenced indictment. Response to state's motion to restrict extrajudicial statements. On or about July 23rd, the state filed a motion to restrict extrajudicial statements. Mr. Williams' counsel statements referenced in the state's motion do not violate the plain language or spirit of any ethical rule. In contrast, the state failed to alert this honorable court that before and during jury selection, when potential jurors were not fully charged to avoid all media reports concerning the indictment, the following occurred. Oh, we have examples. Fox 5 press conference with Fulton County District Attorney Fawny Willis, Esquire, dated May 10th, 2022. District Attorney Willis speaks from 11:21 to 19:07, 20:37 to 21:13, and again from 22:19, 24:18, including the following. Oh. In reference to District Attorney Willis claiming her priority is to prosecute gangs. And there's a reason for that. They are committing conservatively 75 to 80% of all violent crime we are seeing in our community. Yeah, I do believe that includes all
other
the
gangs?
possible gangs,
Or
not
potential?
just this one.
Well, then if you
Probably.
take into consideration that the definition of gang has been expanded
Yeah.
to include like everything,
Yeah.
then
One that just
really you can
briefly
put all crime under
associates.
it.
Yeah.
Yeah.
Yeah, what's the word Miss Love used? It is
Criminal.
no. You have the proper street gangs.
Oh.
You have the criminal street gangs, and then you have the mixed street gang, which she claims the YSL is. So she's really expanding on keeping it extremely vague.
Which you want for a criminal prosecution.
Oh. And so they have to be rooted out of our community. I said just a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, all of the defendants are born and raised in an area about the size of a matchbox in Fulton County. So it's not, if you come here, no, they were there.
They are Fulton.
And certainly, if those crimes are in furtherance of a street gang, then you're going to become a target and focus of this district attorney's office, and we will prosecute you to the fullest extent of the law. We are proud to bring forth this indictment and hopefully to bring justice to a lot of the community who were victimized through the cause you'll see in this indictment. But more importantly, the most important thing we are here to do is keep this community safe. And we believe removing these 28 defendants will keep Fulton County safer. For reference, crime in Fulton County has risen since these people were arrested. Hey, Kat. Elia, living my best life. Thank you so much for your super chat. That is so sweet.
Thank you so much. I just set up a redirect too. So I have this segment going, but I'm bad at setting up redirects, but everyone will end up spilling over here when this motion closes down. We'll party in here.
Oh, thank you. Thank you.
Yeah, it'll be a good time. Time traveling.
Oh, you're doing the
syndication through StreamYard.
Okay, yeah. A premiere.
Well, that is $5 into the to the Wheel of Regret fund because it's Friday.
I might participate. I don't have all the options available to me, and I'm going to tell you I don't have mayonnaise. I'm not doing the spoon of mayonnaise challenge. I'm not doing it.
I think you may need to get some Vegemite and do it on stream with Hella. I've never had it before.
Yeah, for you guys who wonder, what's the Wheel of Regrets? This is the Wheel of Regrets. For every $50 in Super Chats, gifted memberships, or PayPal, I will spin the Wheel of Regrets, which has some alcohol and making you eat interesting things.
We'll have to pretend all of it is rum. All I have is spiced rum.
So if we had reached $50, I would have had a teaspoon of. Where is it? Where are you? Wild sauce, which is habanero, blueberries, lingonberries, garlic, and stuff. But we aren't there yet. So, I hit the shot. Oh, well, yeah. But we are not here for this just yet. We need to read the motion. Let's see, where did I... There it is. Oh, thank you for slightly pie over. Rombo says, I was 15 when I had my first beer. I think I was about 4 by mistake.
Actually, yeah, I think I had my mom's eggnog with some bunch of alcohol in it when I was 5 or 6 by mistake. I took a drink.
Oops.
I thought my father's whiskey was apple juice when I was about 3. Oh, this.
Oh, you just start chugging it because you don't realize it right away, right? Because when you're excited, you're just like glug glug.
Yeah. You really don't understand alcohol and.
Yeah, I don't have a memory of it for apparent reasons. But my father he was very amused until my mother
found out.
Wondered, what's going on here? He drank my whiskey. He did what? My father has a special kind of humor. Yeah, but all of these is from that press conference. And below is a link to episode 3 of the podcast King Slime, the prosecution of Young Thug and YSL, released in August 2023. During voir dire and prior to jury selection, the podcast has since stopped recording episodes, but was hosted by music journalist Christina Lee and honorable reporter George Sheedy. District Attorney Willis made it clear that she cannot provide specifics of the case. However, she has the following. I remember when we first took office, we were screaming from the top of the hills that there's a gang problem, and people were really actually kind of treating us like we're crazy, right? There's a gang problem in LA. There's a gang problem in Chicago. But they did not want to admit that there was a gang problem right here in Atlanta. But we kept talking about facts I knew to be true because I knew crime waves. I knew that one important person got ended, and we got a gang war for several years. And Fani Willis got $36 million in extra funds from Fulton County and by federal grants to clear the docket after the big global event. She has used more or less all of it on RICO trials. And why is that? Well, up until recently, she wanted to become the next Attorney General of Georgia. Yeah, I don't think that will happen anymore because people tend to not like when you screw married men and then lie in church about it. So, but she will probably remain the district attorney of Fulton County.
She got probably. She got like 35 million, you said?
36 million.
36, sorry, I didn't want to exaggerate. And all she did was go after 45 people on RICO charges with that money.
Yeah.
Including Young Thug and all of them, and then Trump, and I think there was another one.
Yeah, you have the police one and then another rapper who...
Yeah, it was YFN.
Yeah.
YFN. So 36 million to go after like 45 people.
Yeah. And the docket is as big as it was 3 years ago.
Yeah. Meanwhile, you have thousands in jail, not getting a trial, not getting a...
People not even getting bond.
Lawyers.
Yeah. It is...
Priorities.
Mm-hmm. So there's transcripts. And then lawyer loves... Oh, that's some shade. Lawyer love, not the honorable ADA love. Lawyer loves motion to restrict extrajudicial statements must be rejected. It is rich, audacious, and hypocritical that the state seeks to critique as unethical the single statement by Mr. Williams' counsel, which contains accurate factual assertions. As an overarching principle, rule of professional responsibility 3.6, comment 1, makes clear that just like the framers of the United States Constitution envisioned almost 250 years ago, when they mandated that those accused of crimes are guaranteed the rights to a public and speedy trial, quote, they're quoting the Constitution. There are vital social interests served by the free disseminations of information about events having legal consequences about legal proceedings themselves. The public has a right to know about threats to its safety and measures aimed at assuring its security. It has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. Furthermore, the subject matter of legal proceedings is often of direct significance in debate and deliberation over questions of public policy. Who wants to read the next part here?
Oh, I can do it. You're going to see me sit like this. So we are looking at Rule of Professional Responsibility 3.6, comment 1, which says, moreover, comments 5A and 5B delineate certain subjects about which a lawyer could speak, which are more likely to have a material prejudicial effect on a proceeding. And those subject areas are more likely than not to have no material prejudicial effect on a proceeding. In a criminal case, comments which are more likely to have a material prejudicial effect on a proceeding include subjects relating to the following. So 1, the character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation, or witness, or the identity of a witness, or the expected testimony of a party or witness. And then 2, the possibility of a plea of guilty to the offense or the existence of or contents of any confession, admission, or statement given by a defendant or suspect, or that person's refusal or failure to make a statement. And that's kind of like, you know, I don't think we even got specific examples of.
No.
Like, so far we're in the clear if we think about the interviews that I'm familiar with, and I've watched a lot of them. So
Yeah, I mean, she doesn't say, there's zero example of what was said. They just, here's that show, the entirety of it. I mean, should the
the judge needs to waste all the time she clearly doesn't have.
Yeah, Judge Whittaker, is she going to look through, I mean, 8 to 10 hours of streams? I don't think so. Dave, do you want to take the next one?
Sure. Where are we? What is more relevant to the issue at hand is the commentary relating to those subject areas more likely than not to have no material prejudicial effect on the proceedings. These subject areas include information contained in the public record, the scheduling or result of any step in litigation. This sounds very similar to ours, by the way. Every factual allegation in the statement made by Mr. Williams' counsel is contained in the public record. Specifically, Mr. Williams has repeatedly in public filings, as well as and through his counsel in open court, maintained his innocence. Mr. Williams filed motions for speedy trial. The recused judge, lawyer Love, and lawyer Hilton have been accused of and found to have run afoul of their duties under the law. And Judge Glanville has been recused and disqualified from his trial or from his role as trial judge based on a motion brought by Mr. Williams. As this honorable court is aware, Mr. Williams' trial is televised live from gavel to gavel. The coverage is available to the public at a click of a link, even when not watched live, as recordings are maintained on www.youtube.com.
That was the court honorable again.
Thus, the likelihood that Mr. Williams' counsel's reputation or repetition of information in the public or findings of the court could materially prejudice the adjudicative process in this matter is absurd. Moreover, the jurors in this case have been provided cautionary instructions and admonitions, countless times, at least daily over 100 plus days of trial, not to listen to anything related to this case.
Yeah.
So what are they trying to do? I missed the first part. Were they trying to say that he can't comment on it publicly?
Yeah. The prosecution filed a motion to disqualify the defendants and their attorneys to publicly comment on this trial. But this raises a question. This trial has been on pause for almost 2 months. I mean, a month and a half now. They will be back either August 5th or August 12th, the jury. That is the plan by Judge Whittaker. Then they have been out of court for 2 months. How on earth are they going to avoid any coverage of this trial? The disqualification of Judge Glanville, for example, that must have been headline news in Atlanta. How can you avoid that as a juror to see that? To hear that on radio, on news reports? Are they supposed to be in a dark room for months on end?
Imagine they're sequestered.
No.
I mean, I don't know what he's saying, but I can't imagine that any of this is going to affect the outcome, given the way that this case is being prosecuted and streamed live. By the way, Nick, you want to see something? This is sort of a teaser for other people.
Oh, you got the mug.
They finally came in.
Yeah.
Finally?
We had a bingo card on the
I think it was
Jodi Arias trial.
Yeah, in 2015, I think.
Yeah, it was about that. It was when this trial started.
Yeah.
Well, Jodi Arias took
That's from the Jodi trial?
Yeah.
Yeah, that's from the Jodi trial.
3-0 wonder.
Three-hole wonder. Do you get it? But
I was
this is
thinking
nice.
Clayton Eckerd
It's
Yeah.
for a
like
second. I thought there was
raised-
something with the other girl.
Oh yeah, no. That's Jodi Arias there. She's the only three-hole wonder.
I wonder how many times that's come out of the record.
we had a bingo because they were allowed jury questions. So after Jodi Arias was on the stand for 5.5 years, there were jury questions. So we had a bingo card on the jury questions, and the winners of that bingo will receive that mug.
What are you drinking out of today?
I drink out of Jody's holes. How about you?
Hey, show her
That's
respect.
why people in civil matters choose to settle instead of going to trial, where it will become public record, televised even, and have us making memes about it.
Yes, exactly.
And then sometimes they get convicted and want to go through it again, like Mark Jensen.
Anyways, I just thought I'd share that. They came in yesterday, I think. But
Nice.
they're really nice. So they're being sent out. I got to get individual boxes for these.
Thank you, Iron Rabbit. Gifted 5 memberships to For the Love of You, Charlene Grand Central Crafting, John Sherry, Moose Toyos, and Marian Newsom. Congrats. I should have Dave read this instead.
No, I don't read.
I don't mind reading.
No, Dave can't read names. It's so incredibly funny when you try to read names.
Yeah, I don't do.
I just
names
steamroll through names and just hope no one is offended if I get their name wrong, because I don't mean to be wrong. I just
Yeah,
I get all the names wrong.
Oh, I intentionally get them wrong.
I always apologize when I try to read names because I'm Swedish. I mean, our pronunciation.
That's no excuse.
My pronunciation of things are bad to begin with. For example, every time I try to say four-quad, it comes out as fuck twat. I don't know why.
I think your English and your accent has gotten a lot better over the last year.
Thank you so much.
Well, you get a lot of practice with us.
Okay. Who is?
Oh, I've got this.
Yeah.
You got it?
So, unlike pretrial comments, which the state is guilty of making, there is no basis for Mr. Williams' counsel to believe that his statement will have a substantial likelihood of material prejudicing an adjudicative proceeding. And then argument 2, adoption of Mr. Stillwell's and Mr. Kendrick's motion for mistrial. So this is Doug Weinstein and also Max Shart's motion. We're going to see a third argument that deals separately with Bruce Harvey's. But here, Brian Steele and Keith Adams are adopting those motions for mistrial only if this honorable court finds that Mr. Williams was goaded into moving for mistrial based upon prosecutorial and judicial misconduct, and thus retrial is barred. And there's a footnote. We gotta love those footnotes in his headers.
Oh, footnote.
So Mr. Williams does not join in Mr. Nichols, so that's Bruce Harvey's motion for mistrial without double jeopardy protection. So Bruce Harvey's motion's cool, but if you're going to do a mistrial without prejudice, we don't want us to co-sign that.
Oh,
So-
no. Do you really want to start over and allow this prosecution
No,
to do better?
What Nicholas is saying is that he'll entertain the argument of a mistrial motion, but only if double jeopardy attaches and the case goes away.
Yeah.
So
Well,
he
what's
wants-
interesting here is that Harvey rule, we're all going to adopt things unless we say we're not adopting something. But here, Brian Steele's saying, I'm not adopting Harvey's motion unless this condition is also met. But Mr. Williams has been forced to remain in custody while the recused judge and lawyers, Love and Hilton, violated Mr. Williams' right to a fair trial, a fair tribunal, right to due process, and Steele's long laundry list of everything that he's always saying that was violated,
And the
causing
like.
Mr. Williams to be goaded into moving for a mistrial, as demonstrated by a few examples, as follows. So this example. Mr. Williams was denied his constitutional right under the Georgia Constitution and federal Constitution to be present at critical stages of his proceeding. See Exhibit A, that's the transcript of the ex parte meeting on June 10th. The recused judge, meeting with sworn witness Kenneth Copeland, was a critical stage of the proceeding in which Mr. Williams and his counsel had, as a matter of law, the constitutional right to be present. So they cite Scudder v. State, In the case at bar, the recused judge, Lawyer Love, and Lawyer Hilton unlawfully influenced Mr. Copeland to testify against Mr. Williams. And they're going down to the transcript again, the specific pages referenced in Exhibit B, the joint affidavit of Brian Steele and Keith Adams, and then, under the federal Constitution and Georgia Constitution, Mr. Williams was prejudiced by being wrongly excluded from this critical stage of the proceedings, where Brady evidence, judicial misconduct, and prosecutorial misconduct was captured and intentionally concealed from Mr. Williams and his counsel. Lawyer Love, and I like how that's a new line and it's still lowercase. Guys, this is a new sentence. And the other one, to be fair, it's in lowercase below it too, but like...
Yeah, but this is with the Oxford comma, so
yeah, so it's not a new sentence.
Lowercase is proper here.
But usually when you format, doesn't it automatically capitalize and you'd have to go back and lowercase it anyway?
Yeah.
I don't.
So they had the choice to leave it proper.
No, it's proper. It's proper now. He made the distinct choice to make sure that it was proper. That's all.
Yeah.
Okay. I do like
proper by his
semicolon.
terms because he doesn't want it to be capitalized.
Props on the use of a semicolon, though. You don't see those often.
So Lawyer Love and Lawyer Hilton will be called as necessary witnesses in this trial by Mr. Williams, as material conversations with sworn witness Copeland are not captured on the transcript of the June 10th, 2024 unlawful ex parte meeting. So they're citing these specific parts of the transcript. So lines 3 to 10, and I don't know if you want to visit these after or whenever, but specific lines here we're getting. And then the specific parts on separate pages, as well as other matters wherein Lawyer Love and Lawyer Hilton must be examined as to other ex parte communications with the recused judge and concealed Brady Giglio evidence.
Yeah, I mean, the way they conducted that ex parte meeting, for me, it really sounded like, and this was a reoccurring event with problematic witnesses. And yeah, I would assume there are more ex parte meetings that we won't find out
for a while.
Unless Judge Whittaker, because Judge Whittaker has been speaking to what's her name?
Court reporter?
The court reporter for Judge Glanville a lot. Because I assume her commentary about the conduct in the courtroom and everything, all of that is from Miss.
Well,
I keep forgetting her name. Judge Glanville's court reporter.
She was also talking to the bailiffs too, and like everybody involved in this trial.
Miss Weaver, thank you. Yeah.
Miss Weaver. Okay, so she really came in and like the first thing she did is like, okay, what is your opinion about everything that's wrong here? And what is, like asking the bailiffs, or not. Oh yeah, I guess the bailiffs, about their opinions on what's wrong. And they're like, yeah, he had way too many clothes. And it's a huge security issue.
Yeah. The sheriff's office complained about the clothing of the defendants.
Yeah. Because
Mr. Williams tend to have a different outfit each day of the trial.
Yeah. And if you can get away with it, great. But I mean, it's still a security issue for the sheriff's office.
Oh.
Well, in Oakland County here in Michigan, you're only allowed one outfit per trial. So
really? Even for women?
Yeah.
Oh, yeah, because that was the Megan. Yeah. Yeah, and that is so that's a common thing. It's not just the.
Yeah, it's unfortunate because I think it's just as bad as showing up in orange. If you're wearing the same outfit every day, the jury sees you 7 days in a row. Most trials only go 5 to 7 days. But
I mean, I guess most trials are 2 to 3 days at most, but
yeah, so get 2 to 3 outfits.
But I mean, especially if you have a longer one. Anyway, sorry.
No worries. Everybody's shouting that Kat should read all of this, but let's have Dali read this part.
Oh, a Dolly voice. Well, I'm also, by the way, I'm looking for Love's response. I'm trying to see the full document.
The recused judge violated Mr. Williams' constitutional right to confront prosecutorial misconduct when Lawyer Hilton introduced a known void, null, invalid, involuntary guilty plea before the jury. Specifically, lawyer Hilton elicited testimony from Detective Rossi about an invalid, void, involuntary guilty plea, knowing that same does not exist under law, to push the prosecution's invalid theme that Mr. Winfrey was protecting the supposed / purported gang members now on trial in the case at bar. The recused judge refused to permit undersigned counsel to confront Detective Rossi and prove that lawyer Hilton was eliciting non-factual and knowing misleading testimony to the petite jury. This denied Mr. Williams his constitutional right to cross-examine witnesses, constitutional right to a fair trial, and constitutional right to a fair tribunal. See Exhibit C, Notice of Attorney Proffer, filed on July 1st, 2024, attached here too. Keep going. Lawyer Love has attempted to demonize counsel for Mr. Williams as well as the other accused counsel in front of the jury. This appears to potentially be lawyer Love's standard practice. See Exhibit D, the appeal. Medical staff at notorious Atlanta jail let autistic teen waste away and die. Ooh.
That is the other case I'm following out of Fulton County.
Yeah.
Sean, yeah, the case of Sean, and it is so horrible. I will give you an example on how horrible. They found Sean unresponsive in his cell. It took the first hired medical personnel 5 to 6 minutes to get there, which is a 2-minute walk.
Oh.
She refused to perform CPR because she had a bad knee. Then her superior showed up a few minutes later, started to perform CPR, but was more or less thrown out of the jail cell because he did more harm than good. They couldn't, neither hired medical personnel could or wouldn't perform CPR. They had this heart starter, and the superior, the other, I believe his name is Michael or something, if I remember correctly, he couldn't attach it correctly.
That doesn't
because
here's the thing, though, with
it's
Love,
shown on the surface of the machine how to do it, and he couldn't.
But I agree with this first statement that Love has attempted to demonize counsel for Mr. Williams in front of the jury. And the thing is, though, is that I run into this a lot where the other side does this, and then you respond in kind, and then the judge barks at you. And you're like, listen, she's been doing it this whole damn time. You're going to yell at me because I did it the one time. It's extremely frustrating. I see it. I've seen Love do this, and I think it's good for calling her out on this. And I don't know this judge, but this judge seems no nonsense, and I don't think she's going to tolerate it going forward.
Oh no. I mean,
anyways, I just wanted to jump in and say I gotta jump off.
See ya.
Kate was like, "Get out of here! Get out of here!
You're gonna miss."
Leave.
Well, I'm trying to find the. It's not Love that responded. It's Fonnie Willis that responded. Fonnie Willis has filed in response to defend Love and Hilton. She's responding to the motion to disqualify the lead prosecutors from the case. But guys, the link. So Dennis Byron had shared a link with where you can look at high profile cases in Fulton County and get the briefings. It's not uploaded there yet. And I can't use the Odyssey portal. It won't let me put my payment information in for Fulton counties. So AV to the 7th power. She says she has the same problem.
Okay.
So waiting to see if Joseph Babb will provide that. Guys, we could be looking at a Fonnie response today.
That would be amazing. I need to repost my video of her. I'll be listening in chat. I just got to get a few things taken care of.
Yeah.
Okay.
And I just got notified by a potentially criminal. He might show up.
Oh, really?
Oh, that'd be so good for if the DA is writing filing a motion on behalf of the prosecutors in this case. It'd be great to have Sean on here.
Yeah.
Yeah.
John's a
Oh.
defense attorney, you guys, a practicing
in Ohio.
criminal defense attorney.
Yeah.
Not you guys, but the chat.
Yeah.
All right, take care, all.
All right. Bye, Dave.
Thank you, Dave. Bye-bye.
Yeah, I'd love to see
Oh.
him on here.
So Fannie Willis doesn't have the confidence in either love
Oh, is that why
or
you
his
think?
son.
No, she's defending them.
Oh,
Okay,
oh,
but
okay.
she's defending them. But is it because she doesn't have confidence in them to argue?
No, she has to defend them because they are the subject of the motion of this disqualification.
Okay, they would need another attorney to write it.
Then
Yep.
she must be in court to argue it. Guys, I told you now. Oh, there's let's see here. There's almost 500 combined people on mine and Kat's channel. I said this a lot earlier. I've made sure I can leave work early because 8:45 a.m. is 2:45 p.m. my time. I need to get home early because Tuesday, 8:45 on the dot, we all need to tune in to this Foster clock. Because I don't know if Judge Whittaker expected this amount of replies, because I'm missing a whole lot of replies here from the state. And they had up until end of business today to file it. Now, it might take the clerk some time to upload it to the docket. So we might even see it until Monday. But just the mid-trial motions from Steele and others must be in their 20s that the judge just punted forward.
Yeah.
And then they still have to reply to everything the defense filed after Judge Whittaker took over.
And they all rely on something that you need to look back on the record for. So that's time consuming in and of itself. It's not, we want to introduce something new. Consider this new thing. It's all these things back on the record on day 30. Oh, well, I need Christina Weaver, who's currently working other trials, to get the transcripts over to me, which takes time. So this August 8th, if the trial is supposed to continue, this August 8th date that Whittaker tried to be somewhat optimistic to, even though she had some caution, she had some reserve.
Yeah.
But the jury coming back on August 8th, maybe.
Yeah.
That optimism has to be gone.
Like, oh yeah. I mean, she's probably looking at the docket wondering what the actual F is, because she wasn't a completely happy camper when she talked to the lawyers and the prosecutors. She set down really hard ground rules. She's an I don't take crap, no BS kind of judge. I haven't seen her in any trials or anything, but her demeanor there tells me, file it correctly, or I will rain down hell on you. And she says it in such a tone,
sweet tone.
That but once you hear what she says, just her way to say to the parties that if this doesn't happen, we have to have a talk. Yeah. You do not want to have a talk with Judge Whittaker. She will kill you with kindness.
Yes.
And this is the diplomacy. Now, my stepmother's brother is a diplomat. He has been in embassies on I won't say the exact ones, but some interesting areas of the world. You don't want to have a discussion with him where you find out you're wrong. Because he will just sit there, smile, he will rip your arm off, he will beat you with the bloody end of it, and you will still thank him afterwards. This is the type of lawyer I believe Judge Whittaker is, the type of judge.
And she said she wasn't really following it that closely, but either she's done a ton of research or maybe she has been, she knows enough to know where she needs to rein things in.
Oh, yeah. Now, where were we? I think it's my turn now. sorry for you over at Kat's channel. I know you only want to hear from her, but this is a joint stream. So I will just say a little bit of things to rest Kat's voice, and then she will start talking again. Lawyer Love has attempted... Oh, we read that. This appears to potentially be Lawyer Love's standard practice. See Exhibit D, the appeal medical staff at Notorious Atlanta Jail. Prosecutorial misconduct has been perpetrated by Lawyer Love from the inception of this case in order to goad Mr. Williams into moving for a mistrial. Exhibit E, motion for fair trial. The above few examples prove, in the event of any wrongful conviction of Mr. Williams, there is a substantial likelihood of reversal by an appellate court, including a court presiding at a motion for new trial. Therefore, the continued incarceration of Mr. Williams is punitive without legal justification. This past month and a half alone finds Mr. Williams helplessly trapped in a cell based upon the intentional misconduct of lawyers Love and Hilton and the recused judge. This delay in causing this honorable court to parachute into the case has infringed upon Mr. Williams' freedom. Respectfully, bond must be granted. This continued incarceration of Mr. Williams is unconscionable, as has much of this trial under the guiding hands of the recused judge and lawyers Love and Hilton. The prosecutors and recused judge, Mr. Steele really likes saying recused judge.
Yeah, that'd be a dangerous shot counter.
Yeah. And for you who don't know it, Attorney Steele has a very good appellate, he's won a lot of cases on appeals. And he won twice against Judge Glanville. Yeah. I like Mr. Steele. I really, really do. I hope to meet him in some, maybe just in passing during lunch when I'm in the courthouse, unless Miss Love sees me and throws me in jail. I'm trying to get...
I was going to say the other thing, too, Dennis Byron had pointed out, with Whitaker on the stand, if the appeal reverses any decision from this point, wouldn't the reversal stick on her record? How does that work? Do you know? I don't know. We need... Maybe that's a Sean potentially criminal question.
Yeah, that's a Sean potentially criminal.
Let's bookmark that, you guys. Remind us in the chat if Sean pops on potentially criminal. We'll ask him.
Okay, I will try to do. I'm just reading and talking. I will try to make it now.
I can read 6. I don't mind reading.
Am I done? No. The prosecutors and recused judge misconduct and trampling of Mr. Williams' constitutional rights has forced Mr. Williams to timely move for several mistrials after being goaded into same. This quote-unquote trial is not fit for a kangaroo.
It's not even a kangaroo court anymore.
It's not even a kangaroo court. Oh, the shade. The shade. Oh. All right. Now you're all over at Cat Not Williams.
And then, by the way, chat, if you guys see the full document for Fani's response, or if you want to go and get it from the Odyssey portal, I'll cash app you. It's like 50 cents a page. But I just can't pull it up from the new link that Dennis Byron gave me. It's not uploaded to that yet. So if anyone wants to get the document, send it over to us. We'll definitely read it. But argument 6. Mr. Williams lawfully filed a statutory demand for speedy trial. No reasonable person would argue that a speedy trial has been satisfied. For example, the recused judge ordered Mr. Williams to be held in custody without bond since May 9th, 2022, while over 2,000 potential Veneri panel members were mostly individual vardard for hardship. So that was remember when they did jury selection, they expected it to be 3 to 6 months that they would need to be sitting for this trial. And that was the time period, the constraint for hardship. There was no valid reason to summon over 2,000 potential jurors, since the petite jury was selected from the first 511 jurors, who were all summoned to the courthouse on January 4th, 2023. Undersigned counsel will be inquiring of the recused judge as to the reason that Mr. Williams had to endure suffering in custody, months of unnecessary individual jury hardship questioning. This unnecessarily elongated process of jury selection was a waste of time and violated Mr. Williams' constitutional and statutory rights to a speedy trial. This continual waste of time has caused Mr. Williams to be wrongfully denied freedom and a fair, speedy, constitutionally sound trial.
Yeah, I mean, the jury selection alone, how can that take 10.5 months? If the first 511, who was all summoned to the courthouse in one day? Now, it was amusing with the throwing a few of them in jail for recording in the courthouse. I mean, that's not a bright idea, and other things. But 10.5 months for jury selection is...
And then for them to pick the first ones anyway. Kind of like, and then I saw, Dave, I saw your chat to email you the information I need. I just DM'd you on X the portal link and the case number.
Okay, great.
That might be in motion. Thank you. And then, are we on 7, right? What's highlighted is new? Mr. Williams have given reasons for bond to be granted. We just read that renewed motion that came in this week. That was Tuesday that came in. In order to be released from the unlivable, inhumane conditions of the county jail that he has wrongly endured since May 9th, Mr. Williams has offered conditions of bond to include release with 24-hour surveillance by law enforcement. While Mr. Williams is not a significant risk of flight or a significant threat to others in the community, and thus does not need law enforcement to surround him, he has, however, offered this extreme provision if this honorable court wishes to apply that condition. However, under all circumstances, a pre-verdict bond must now respectfully be granted. The past will not be forgotten, but Mr. Williams' improper detention and unlawful suffering must end. Furthermore, counts of this indictment failed to allege at least one essential element of the crime. Thus, there is a fatal variance and jeopardy has attached to this. Thus, this case can never be retried and should be dismissed at this time, as a general demurrer can be filed at any time. So I guess that's going to be G. I don't know if that's new. The recused judge denied this timely filed plea in bar / motion to dismiss / general demurrer, and then denied a certificate of immediate review, and thus this Honorable Court of Appeals of Georgia dismissed Mr. Williams' direct appeal for lack of jurisdiction. And then skips to the bottom. Thus, the law of the case doctrine does not apply to Mr. Williams, and Mr. Williams asked this Honorable Court to decide this general demurrer issue, so this case, or counts thereof, can lawfully end now, and now, instanter. So wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, asks this Honorable Court to grant the above requested relief. So put a 1 in the chat if you think Love is going to respond to this and say, Brian Steele didn't even lay out what he's requesting for relief.
Okay. We're only on page 12. Are the rest exhibits? Oh!
Yes, I think we got the trial transcript was the first one, so that's like long. Do you want to actually, let me pull up this motion, and do you want to go to the trial and I'll pull up the footnote?
The who, the what, the when?
Okay, so Thugger Daily is saying the full document is inaccessible to me right now. The state is also expected to have filed other responses today, but since it's after hours, it's assumed that they'll come in Monday. So there's that part. So Thugger Daily might mean he's just on the run right now. I'm not on the run, but like doing something away from a computer.
Let's see here.
But let me pull up those footnotes. We can see the exact moments. It's probably going to be breaks in the conversation in the transcript.
Let's see here. Well, we have the initial page from Joseph Papp. We can go.
Yeah, let's look at that, because that's where you get the big, like, this is the DA.
Let's see here at the stage. Oh, let me. There. In the Superior Court of Fulton County, State of Georgia, state's response to defendant's motion to disqualify lead prosecutors. The State of Georgia, by and through Phoney, whatever's, Willis, District Attorney of the Atlanta Judicial Circuit, hereby responds in the opposition of defendant Jeffrey Williams' motion to disqualify lead prosecutors, Chief Deputy District Attorney Adrian Love, CDDA Love. Folks in the chat, what does CDDA actually stand for? Post your suggestions in the chat.
Chief Deputy is not the correct answer.
Not that C word, but other C words, because we like our streams.
Chocolate donut. Cookie dough. Cookie dough. All my guesses are going to be food. That's the way my brain works.
Yeah, so folks in the chat.
Dolly. I'm sorry.
Yeah,
I'm okay.
Post your suggestions. Post your suggestions of what CDDA love. Oh, with her last name, that can be interesting. All right, let's just continue. And Deputy District Attorney Simone Hilton, DDA, filed on July 10th, 2024, and on July 18th, 2024. Despite the extraordinary nature of the request to disqualify the lead prosecutors in this case, defendant cites no facts and no law that authorize this honorable court to disqualify either CDDA Love or DDA Hilton. Well, they explained quite thoroughly through their conduct in the trial, including not limited to the ex parte meeting and a lot of other examples. I don't think this is correct at all. Cites no facts, but they cite the ex parte meeting. Miss Love, I know you lie in church, but don't lie to the court as well. I mean, you can get away with lying in church because it's not punishable. Lying to the court and to this judge as the first action in this case with this new judge presiding. Oh, I want to. Oh, the reply to this. Oh, the reply to that specific line from this motion from the defense. Oh, Phoney Willis, you wish you were still in bed with Nathan Wade.
Don't we all?
Yeah, by the way, I don't know if... let's see if I can find it here. Yeah. For you over at Kat's channel, you might not have seen it, but I obtained images from the Aruba cruise with Miss Love and Nathan Wade. Let me show it. I'm quite sure that is authentic. I want for if Miss Love doesn't put me in jail, Miss Willis might. And I will have content for years. The time I was thrown in jail by these hussies. Oh, did I say that out loud? Oh, sorry.
We'll contact the lead attorney to help save you.
The document is on that thing that I can't purchase from. I don't know why it doesn't let me. But it's saying that it's $4.50 total at 50 cents a page, so it's 9 pages long. So
did David?
That's actually longer than normal considering the other ones.
Is David trying to get access to it?
Yeah, I think so.
Okay.
Unless he disappeared.
Well, that sounds like David.
Yeah. And I have another source that is also trying to get the full doc, but they can't access it either. So this might be
Damn it,
Yeah,
Fanny.
I don't. Yeah. Damn it. Now, where were we? Accordingly, the state respectfully moves this honorable court to deny defendant's motion to disqualify the lead prosecutors. In support of this response, in opposition to defendant's motion to disqualify, the state shows this honorable court the following. 1. Where defendant seeks to examine the prosecutors on matters concerning which there are other sources of evidence available to defendant, the laws of Georgia and the facts of this case mandate this court's denial of defendant's motion to disqualify. In support of his motion to disqualify the lead prosecutors, defendant asserts that Lawyer Love and Lawyer Hilton have made themselves critical witnesses in this case. When CDDA Love engaged in text messages with a witness and then CDDA Love and DDA Hilton participated in a hearing in chambers with a witness and his lawyer regarding contempt proceeding against... and that's all we have. That's all we have.
Dun, dun, dun.
Dun, dun, dun.
So yeah, and it's not. I know there the jokes that Fonny's blocking this from becoming accessible, but I mean, maybe that was strategic in the timing that they filed it. Right, that's a possibility. Filing things late on a Friday, but which is stupid because they should know that all these YouTubers will go live on a Friday night to read their documents.
Yeah,
That's what we do
have
for
no
fun.
life. We have no life. I mean,
We'll do it.
We drop everything to go live.
Yeah. But it's the same. The portal
We're
I'm
cool.
seeing it in is the same portal that's always a problem.
I'm guessing there's a lot of traffic, and it's just
No, it's just it never lets me set up a payment account to pay for the document.
Oh,
It just gives me a 4014 error when I try to purchase the documents. So they don't want my money.
I don't need your stinking money.
I just put the long link in the private chat. I don't know if it'll take you to the document itself or make you try to create an account, but
yeah.
I'll try. I got 450.
Now, here's the thing. I can't ask of any of the lawyers in this case to send it to me because it needs to be filed to the court and uploaded to the docket.
You got to do it officially.
Yeah. So
did the image have the marking on it, or that would just be the electronic submission stamp?
I wouldn't want them to get in trouble either.
Because it already says Clerk Shay Alexander at the top.
Okay, I have to create an account for Odyssey. I'm going to try this.
I don't know what it is. It's just been this the whole. I've never been able to add the account. I can just look and see that something new came in and see page 1. And then it's cool, page 1. Which was great the day that Brian Steele had 3 footnotes in a title on the first page. I could see a lot. But most of the time that doesn't show you very much.
dun, dun, dun.
But I like reading Fonny's arguments, her writing, because she uses bold, underline, and italics all at the same time to emphasize things every other paragraph.
Oh, she makes her motions look purty.
Well, and I feel like I can yell those parts when I read them. I can get louder. And no, I'm not using a VPN. Do you think that would help? I thought maybe
No. Well, you're in America, right?
Yeah.
Yeah, no.
But I'm in yeah.
I don't think it matters as long as you're in America. I know Hella has some issues because she's in Australia. Accessing court documents and stuff.
That's so annoying.
Yeah. Because I have to fetch them for her.
Shout out to Dolly. The document whisperer.
Yes. I'm trying to create an account and get it, so we'll see. Sorry, guys.
Oh, that's okay. It's a pesky website. It's this is their updated Odyssey portal too, by the way. And it's very clunky.
This looks like a government website to me.
What's interesting is Joseph Babb didn't get it either. And
Yeah.
he's posted screenshots of it before, but
Yeah, but you have the front page, which we just read. That is what you see, and then you have to purchase the rest.
yeah.
And that's a bit annoying.
Well, this one's only like $4, so that's worth it. But yeah, it is annoying.
Is it letting you create a payment account?
I haven't tried yet.
I'll be so happy for you and for us to read this document, but I'll be so annoyed if like you just magically figure it out. I've tried so many times.
No, damn it. No, server error in portal application. The resource cannot be found.
Refresh it. Try and refresh it. Maybe it'll do something.
No.
Because sometimes it won't show you the first page of the document until you refresh it, and then it suddenly shows it. And then Hank Deasy, thank you for the super chat. There is maybe an update on bond responses. I think that's responses to it, not an update on the decision from the judge. But Thugger Daily did say more motions. It's expected that more motions have been submitted by the state today, but it's just not going to show up until Monday because it's already so late on Friday. So one of those responses could be in opposition to those renewed motions for bond. So, and then the opposition really doesn't help. It's really what the judge would end up deciding. And hopefully that's the first thing addressed on Tuesday.
Yeah. And what's interesting there is so far during the trial, not one witness has expressed fear for the defendants. So how would... Now, you have Attorney Melnick's statement in an email, you're going to kill him. That's the one thing. I don't... in my personal opinion, now, folks, I am a bit biased. I admit.
Get him killed. And it doesn't mean by a defendant.
No, just that snitches get stitches. And if he talks to the cops in this case, he might talk to the cops in other cases. And I've heard the rumors of other criminal elements in Fulton County that aren't these 6 individuals. I don't know if that's true or not, but yeah. Impeachment festival. Yep. I don't fear the defendants. They in jail. And here's the thing.
I was gonna say, I feel like I'm trying so hard to read 8 more pages. So I didn't mean to interrupt what you were saying. Just like...
I mean, especially if they claim Woody is scared of the defendants, Woody isn't afraid of anyone. No. I mean, he does not have fear. I mean, I would almost submit it should be the other way around. That people should maybe be scared of Woody. Because he's not nearly as oblivious as he portrays himself in court.
Oh, no.
That is a smart guy.
Oh, yeah.
And I heard rumors that once upon a time he was considered top 10 of dangerous individuals in Atlanta. You don't get that from out of nowhere. Just saying. Now, one thing I've been meaning to... Now, when we have Sal on and Kat on, I don't know if I asked this question, but what do you think about his statement in the ex parte meeting? I did these crimes. How is that not Brady material?
Well, it's definitely Brady material, obviously. I mean, I don't think he did it. I think he was just screwing with the prosecutor at that point. Because they're like, well, I'm going to give you immunity. So he's like, oh, yeah, well, I'm going to say I did the crime they did. So
I don't think it means he didn't do it either. It could just be layer on layer of just rewinding it, and I'll just say this and then that and then this and then that and then this and then that. Like, you just don't know. The credibility is so far. Like, his goal was to get rid of credibility, and he's done that.
Yeah. And I mean, they can't say like, okay, yeah, he's testifying against them, but at the same time, he's like doing everything to screw with the prosecutor. and make himself not believable. Oh yeah, I lie to the cops all the time. I tell them whatever they need to hear.
What, a little bit of truth, like what color, what the weather is, just a little, like the spoonful of sugar for anything else that I need to tell them.
What color shoes are you wearing? What shoes you got on?
She made a LinkedIn post, Kristen Weaver, the court reporter. Really? Yeah, she's like, when you get brought into the trial on accident, and like a bunch of other court reporters, because you can see the job title in response, like, oh my God, I've had something like this happen to me. So it was just a LinkedIn thread of court reporter moments.
And like the next day he comes in, hey, I like your shoes. He's not, I want him to testify again so bad.
Oh, and that's true. Yeah, Fatima Barrett's adding, and then he also said, and then I'll lie. Like,
and then I'll lie.
But what were the lines that Brian Steele was pointing to in the transcript? I'll pull the pages if you want to go to the part of the transcripts. I can reference you what page to scroll to. That way you don't have to scroll. I have it up. I have the pages. So if you want to pull up the...
but I don't have it. Just post it as, yeah. Or present it, or...
Have you tried to set up a payment account before today?
Yeah.
Okay, so it isn't just...
I'll like wake up in the morning and see if I can download the documents today.
Okay. That's weird then. I was wondering if like they were doing updates or something, but...
That's what I thought the first day, and maybe the second day. I'm like, wow, they're taking a long time to fix this.
Okay.
It's been multiple weeks. Probably more than 2 months now.
Oh.
I'm trying to create an account, but I don't have an American phone number.
Oh no, I sent the link below that for the document we already read. Because the transcript's an exhibit in there, but I want to see what lines Brian Steele was singling out to see if it's what, people on YouTube were saying, hey, that sounds incomplete.
Michelle for $10. Thank you so much. Thank you so much. March 2023, Glenville ordered an investigation on who leaked the Woody video. What was the outcome of that investigation? I don't know.
Probably still pending. I don't know. That's just a guess.
Yeah, I would assume so. Now, once I get to the United States, I will get an American phone number because I purchased a phone and a blank phone, and then I will have one of these AT&T 30-day tourist internet thingy.
Well, David,
I just sent the title to him. It's state's response to, and I sent it to you, so you don't have to type it all. You don't need to write it down, but it's state's response to defendant's motion to disqualify lead prosecutors.
Like, if you have already a payment plan in this thing, then maybe you can do it.
I do not have a payment plan.
No, I know. None of us do. I'm hoping David does. Already set up when it was working.
So I have payment accounts in other odysseys, just not, it won't let me do it in Fulton counties.
No, but my other source has, but she doesn't get it. No, she has an account on the Fulton County, but she doesn't get it as well.
Well, I have an account now too, but like you have to have a payment plan, and the payment plan link is what's broken.
Oh, that's crap.
Yeah, so it's like the resource cannot be found, the epayment.aspx link.
Okay, which line are we searching for?
Yeah, I think MLS God of Law is having the same issue. Okay, so
Okay.
the lines we're looking for. So first one was page 22. Oh, thank you, Kate Aiden. Thanking
We're
us for
trying.
working so hard for us. Like Dolly said earlier, this is what we do. We have no
Yeah.
lives.
Yeah,
This is
I
fun
mean,
to us on a Friday night.
this is what we know. What you see now is what we normally do. What you don't see.
Yeah,
Desperately
exactly.
Yeah.
trying to get hold of information. We just sit in
Yeah.
front of the computer, often more silent,
Darn it.
or a lot of cursive words, and going, "What the actual f? Why don't I get? Oh, that way." And then you find information from one source, a third source, or a fourth source. Okay, over there, over there. I mean, every 1 hour stream is probably the same amount of time of research. And
Yeah.
well, except for Sal, who got, for you who don't know, Dali here requested the entire discovery of what's the case again?
The Rust trial.
No,
The Alec
should-
Baldwin
yeah.
stuff, you guys.
Yeah.
So, and the Hannah trial
With the
and
Ozark.
Alec Baldwin's trial.
Yeah.
So all the text messages, you have
Body cams.
a very suspicious guy hitting on the lead detective. At least that's how I read the text messages.
Yeah.
You get to see how Alec Baldwin texts the detective to ask if he's going to be charged with anything. All this good, juicy stuff. Really, really, really good stuff to look at, especially since the trial
Ended.
Yeah.
Yeah.
It's so much fun.
Yeah, and Dali needs more subscribers and more people who watch his content, because somehow when he started to do the Baldwin after the trial ended, he get less views than normal. This should have been.
I know.
And so we are suspecting a shadow ban. So people, please, if you wouldn't mind, subscribe to Dali and make sure he gets some views in to break through that possible shadow ban. Now, this is not the first case Dali got all the discovery from.
Well, it's the one I'm most proud of.
Would you please, Sal, would you please explain to 500 people here, what case did you get the discovery from, and what was the discovery?
Mark Jensen. He was a man in Wisconsin, Pleasant Prairie near Kenosha. He unalived his wife with antifreeze. The man had a curious hobby of downloading and collecting photos of male people and organizing them by size. That all came out in trial twice, by the way. He got a retrial and had to go through the humiliation again.
Yeah. So Sal has on his computer how many pictures organized by size?
Well, only 800.
So if the FBI ever goes through any of us computers, our search history will implicate us as the search history we have is not of the normal people.
I was so happy to go with Baldwin, get a fresh start, get away from the degeneracy, just focus on a new case, be more professional, build up my stream, make a name for myself. And I'm forever linked to Mark Jensen.
It's Salvador Dali, the Peen Man. I'm sure you will find another trial that will overcome that.
I hope.
Unless we bring it up over and over and over again because it's funny. I didn't actually think you would get that discovery. And I
didn't either. I was kind of glad I didn't think I would get it. And then MLS David was like, well, I emailed Kenosha Police Department and got Zachariah Anderson's interrogation. I was like, oh, well, you don't have to contact the court. You can also contact police departments.
Yeah.
Well, I'm going to do that. And I was like, can I just get the discovery and all the evidence you have for Mark Jensen? They're like, sure. Here you go.
They're probably so happy to plop that on some unsuspecting person.
Here you go.
Oh.
They give you 2-3 gigabytes.
Oh my gosh.
Now, have we found out yet what the lines he is referring to?
Yeah, so the first one was on page, I think it was 21. Let me pull that window back up. I have a lot of windows now. Hopefully I didn't just close the one. Yeah, so page 22.
Page 22. 22! Okay.
And then lines 3 through 10.
But let's see, do I have it up? Yes, I have. But what we overheard being said was, quote, they are going to ham you, end quote, as if we were going to expose Kenneth Copeland too. Miss Bumpus, you heard that? Miss Love, yes, yeah, Mr. Melnick told Mr. Copeland we're going to hammer him. The court, now to be fair, and I think Miss Bumpus as an advocate or anybody has got to tell him he's going to face some pretty significant cross-examination.
Okay, so that's where he said to cite to on those pages.
Mm-hmm.
So maybe they mean that dash.
Oh, those dashes over here.
And then the next one was page 40.
Let's see if I can get it up into Google Doc. Oh, that looks like crap. Google Docs is not an option, by the way. Okay, next one.
Page 40.
Page 40.
And then lines 20 through 25.
Mr. Copeland.
The end of that paragraph? Well, so I guess it's maybe between that paragraph it's saying something was missing because line 20 is... Oh, wait. Page of the transcript, not page of the PDF. Are you on the page of the transcript or are you the PDF page 40?
I'm PDF page 40.
So go to transcript. Let's go back to transcript page 22.
25.
So let's start back at 22. Transcript page 22.
Nine? Oh, too far.
Okay, so on 22, that was the lines 3 through 10. So yeah, so when Mr. Copeland's entered the chamber, I think maybe we're indicating that we don't know what happened before that. Maybe.
The proceedings stood in recess from 9:34 a.m. to 10:03. Okay. Mr. Copeland entered chambers at 10:03 a.m. Also present was Judge Glanville, Assistant District Attorney Simone Hilton, Attorney Kayla Bumpus, Court Reporter Christina Weaver. And the court, okay. So it's the gap between 9:34 and 10:03, what was discussed then. But it's just that the proceedings stood in recess.
And then the next one would be on transcript page 40.
Wait a minute, it's the page number on the bottom of the page.
Yeah.
Okay, let's go back to 22. Because I read the next page. Pages 3 to 10.
So wait, let's just pull up the transcript doc, because I think... Let me pull up the transcript. And I have it searchable, so we can search 22. Mm-hmm. Well, 22 will show up on every line. That's not a good idea. So this is the transcript then. Let's use the doc I just sent in the private chat.
Okay, let's see here.
And then go to page 22 of that. Good call, chat. Good call, Gavin.
I love that chat because they bring us in line. Let's see here.
Okay, so 22, 3 through 10. Is Glanville exiting?
Exited chambers at 9:33 a.m. And then they keep talking. Miss Love, we would like to just go into another courtroom and talk to him. Give you a chance to talk to him. and then give you an opportunity to explain to him. The court reporter, we're off the record. Brief recess. Judge Glanville and Mr. Chamberlain enters chambers at 9:34.
But look at the beginning. It's asking, is he here now? So then he leaves. He's obviously not in the room. Then Glanville leaves.
Yeah.
For whatever
Yeah.
for that moment. It looks like one moment.
Yeah. Let's see here what is going on.
But that could have been, maybe he saw Hilton and Copeland like standing in the hall talking somewhere too for that moment, like glanced out, saw them, which is why he said, I didn't inquire. I didn't try to look at video surveillance of what was going on in the hallway during this ex parte meeting. And I happened to notice this other video of Kayla and the defense attorneys all standing with each other. But maybe he was looking at those videos to see if he was popping out notably at that moment.
Yeah, Judge Glanville exited. Ms. Love, we would like to just go into another courtroom and talk to him. And then corrects herself, give you a chance to talk to him, and then give you an opportunity to explain to him, ... Court reporter, we're off the record. So Glanville exits 9:33 and enters again with Mr. Chamberlain at 9:34. And then they just pick up. Something is said in that minute. Even though...
Yeah, and I think if they were talking with Woody, Hilton could have been standing right in eye shot, and that something could have happened in that 1 minute. You don't need to walk very far if they happen to be right there.
Yeah.
So, and that would also be like pretty obvious to someone else hearing stuff. The next page was page 40.
Yeah. Miss Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. So at this point, it's only Miss Love there, not Miss Hilton. Where is Woody? Where is Miss Bumpus?
And Love obviously already knows Hilton is with Woody, right?
Yeah.
So...
Let's go to page 40. 40, okay.
And then lines 20 through 25.
What will get you in trouble is you just invoking your Fifth Amendment privilege because you have been given immunity. Or as Miss Love said this morning, remember, Miss Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement.
And that was, so the third part was just that line 1 that you just read on the next page. So that's where we're saying something's missing. Now, what's interesting is none of the motions went into detail about these specific parts being where they think something was missing. But in this motion, here we're getting the specifics. So
yeah, that's weird.
That's why I think it's interesting, is because we've speculated, we've heard conversations about it. But we haven't seen a defense attorney zoom in on specific pieces. Yeah,
and Woody on Miss Bumpus' stream, Miss Bumpus asked Woody on her stream, is the thing complete? And Woody just did this and said, you know that.
Yeah, so the wording in the document is, we need to question lawyer Love and Hilton as necessary witnesses in this trial by Mr. Williams, quote, as material conversations with sworn witness Copeland are not captured on the transcript of June 10th, 2024. So they're saying that paragraph right there and the other part, they're not saying might, they're saying they're not captured.
Yeah.
So Brian Steele has a further indication here of something.
He has talked to someone who might have heard something.
Yeah.
And I mean, Brian Steele has put his bar card on the line several times in this trial.
Oh, yeah.
Primarily because Ms. Lovis keeps lying to the court. There was this specific instance regarding what was heard in a video. And Ms. Love represented to Judge Glanville there were only 3 lines spoken in that video in order to make George Glanville go and look at the video. And at the
I think he was telling on himself by trying to come at the others for being on a video in the hallway.
Yeah. Mm.
Have we confirmed who told Steele about the ex parte meeting?
It's not confirmed. It's
Okay.
highly probable that it might be Miss Bumpus.
Okay.
I think Melnick could be the messenger.
Yeah, Melnick
Honestly,
could be the messenger.
Woody could be the messenger. You never know.
Yeah. Yeah.
Okay.
And
but
I
it's
think-
not been released.
George Glanville strongly indicated it was Miss Bumpus. But
Yeah.
I mean, there might be a security personnel who is just fed up with the shenanigans. You don't know. We don't know. Hey, over at Cat's channel,
Aw,
GGT.
Gigi. So thanks for being so genuine. No, thank you, Gigi. Gigi's
you-
actually one of my favorite people to see in the chats too, by the
Yeah.
way.
Yeah,
She's
you have
great.
a GG too, because I have a GG.
Oh, is
She's
that
my
a- oh.
first
Yeah, there's
and
2
best
GGs.
moderator.
You have a mod Gigi.
Okay.
Yeah.
I
Mhm.
thought she changed her profile picture. I was wondering.
No, but I always recognize by the G.
Now,
And then your interaction with all your subscribers, paid members, super chat or not, is refreshing.
Oh.
I try.
Hey!
I actually feel really bad because I can't keep up with comments when there's when it's like a stream that's live when a new motion comes out.
Yeah.
There's
Yeah.
so much conversation in the chat that I can't. I'll try to read something and it'll be so far off into a conversation that everyone's diving into in the chat. And I'm like, I don't know what we're talking about,
Yeah.
so I'm just going to say hi.
yeah.
Just
And
hard.
I mean, my chat has been so generous because during the winter, end of last year, Gigi, my moderator, had a medical issue that more or less put her in economic dire straits. And so I brought that up to my chat that if you, via PayPal, send and put Gigi in it, I will refer it to her because I don't want to reveal her actual name. And so far, I have been able to send over, I believe, something of the sort of $1,300.
That's really
Because
nice.
my chat just said, we need to help her because they lost their home. She had to move into her daughter's. Now they are moving out into their own home again, Gigi and her husband. And it's so good to see that my chat was a part of them being able to turn their economy around somewhat in order to be able to get their own home again. I mean,
Moving
thank
sucks
you.
too.
Yeah.
To be in bad spirits, to feel like an unexpected finance change happens, and then you've got to move during all of that. That is like the worst combination of things to happen all at once.
Yeah. Now I wonder. Wait a minute. I have 10 gifted memberships from Iron Rabbit. And then I have this. And then I uninstalled another. I think we're at a spin of the wheel.
Well, while you're spinning, since I already know what I'm going to have to drink, I'm going to get my little teeny. This will be my first time ever having a drink during streaming hours.
Wow.
So I'll be right back.
It's Friday afternoon. All right, folks, you are about to witness the Wheel of Regret. It is a sour shot. What is a sour shot? This is sour cola. Hello, I'm Nick. I'm the one who doesn't have Coke on stream unless it's in liquid form.
How about cold SpaghettiOs?
So, what's the shot? It's about there. might be a bit more.
I have
So
Diet
this is
Coke
what
on
you
stream.
get every $50 in super chats, gifted memberships, and or via PayPal. And 30 people left. Just because Kat left.
Aw, she'll be right back.
She will be back, folks. She will be back. Don't leave us. This is the difference between smaller. I mean, none of us are huge content creators, but Kat has more than me and Sal combined, subscribers and stuff. So yeah, yeah, this is sour. Cheers. But it's good. Once the sour disappears, it's actually good. Oh, but damn, that is sour. This is like liquid. What you call it? That candy thingy. Sour candy thingy. What's it called? Oh, Snivels. Thank you. Gifting 10 memberships. Thank you so much. And it was gifted to, let's see here, Keysmobile, Tosha, Eric Rose, Emma. What the fuck? We're over 2 hours. Nilwolf Sarlus Wolfhound. Dime Philidiva. Kelly Waller, Janet Klinger, John Jones, Mimi. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yeah. Thank you so much, Snivels. Now you have access to all my members-only content on my channel, which is a lot. But my members-only is more about me personally, like the farm, the renovations, my personal thoughts on things. So it's more on a personal level, so we get to know each other better. For instance, if you are Sal,
Yes.
You know this. What does the license plate of my tractor say?
Fork.
Yeah, I have a tractor. I have to find it. I have a
Am I good to go? Or
yeah, you're good.
Good?
Yeah,
Right.
Oh, I already took mine. So, hey, Cat!
I couldn't find my cute little mug.
Oh, I thought you went to the store.
No, but honestly, it's Florida, so I probably could go to one that quickly.
Fair. Yeah, I live in Mesa. Trust me, we've got an alcohol store on every block.
And they're open late here too. When I moved down here, I was like, "That's so weird."
Oh, yeah. They're open to like 2. Yeah, here. But they're classy and they close. No alcohol after 2 until 6 a.m.
Yeah, you gotta have that 4-hour break.
Yeah, God forbid. Gotta sober us up somehow.
It's spiced rum, you guys.
Ooh.
Although when I went out, my roommate's birthday is coming up on August 5th, so we're gonna have to get some other stuff in the house. He likes lighter alcohol, fruity drinks. I'll leave it at that.
Great.
Yes,
Like
folks.
Mixed drinks, no shots.
I have a tractor that with a license plate. Fuck. That's my tractor. That is one of them. I needed a smaller tractor, but yeah, that might be the major reason I bought it. It since has been cleaned up a bit. I need to rewire it and stuff like that. But yeah, that's my tractor. It is a Ferguson F15 from 1954. Thank you. Bliano Fever, he became a YouTube member. Hey!
some of that old machinery is
Right.
good.
Member for 14 months. Thank you so much. Hey, Nick, long time no chat. Nice to be back. Welcome back. You have been gone for a couple of months now. Where have you been? I hope everything is all right with you, Rayman YYC.
You've got to do a little member emoji spam to celebrate that you're back.
Yes. Member emoji thingy. Yeah, you have special. These are my members only emojis. You have glad Viking, happy Viking, loving Viking. And then I have the boomer moment because sometimes I mute myself without realizing it. And then my chat is spammed with boomer moment. Then the tractor, female Viking, the three-hole wonder, as in a bowling ball. And then you have Jingles, who is my mascot. Jingles the cat, and then Christmas cat. Now, if you wonder who Mr. Jingles is, this is Mr. Jingles.
Aw.
Hello. Hello. Look how happy he is when I do this. He is so happy. He really enjoys me doing this, showing him to the audience. Look at this happy face. He is not plotting to kill me in any way, shape, or form.
No, not at all.
Oh.
I tried to get Babu, but he didn't want to.
I feel like I'm the only one without an actual cat. All I have is me.
Yeah, for you who don't
Oh,
know,
you're a cat.
we are all a part of the Mr. Jingle Viking Thug Gang. We might be a criminal conspiracy in the state of Georgia. And Mr. Jingles is our supreme leader. Oh. 3 cats. Okay. I only have one because Mr. Jingles is chasing other animals away, or let's just say he stacked up in the barn of things just in case I didn't feed him. So he had 3 hares in a pile in the barn.
Jeez.
This cat catches hares.
Oh, here's Babu.
Oh no, Rayman, what was it? I was in the hospital for a few
nice.
months. Had a stroke, been out and rehabbing for another few months. I'm so glad you're back. I did not know this. And for you who know about Mr. Oh. Yes, Gavin the cat. He's not my cat. I am his human. Yeah. We're very glad you are back, right, Rayman YYC. Very, 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 very happy. You have been a staple of this community for, well, more or less since I started doing this. You were one of the first people, because I got monetized in March of last year. You have been a member for 14 months.
Wow.
So you are one of the OGs of this channel. I'm very happy you're still with us. I'm glad you are rehabbing and is functioning enough to send me money for some odd reason.
Yeah, it can be rough, so I'm glad you're
Yeah, we are very, very happy you are still with us. Thank you for being here, and I hope you continue to contribute to this little channel of mine. Thank you so much. Thank you so much.
Get better.
Yeah, get better. Get better. Hares or rabbits? No, there's a difference between rabbits and hares. Just saying. There's a difference. Yeah.
I learned yesterday that skyr isn't our yogurt. Or I don't know if that's how you say it. Skyr. SKYR. It's actually cheese.
Oh.
Huh. Let's see here. There's a difference between rabbits and hares. Let's see here. Let's look at the Britannica. What's the difference between rabbits and hares? Well, this is interesting. If you ever watch Looney Tunes, you may have noticed that the words bunny, which typically refers to young rabbits, rabbit or wabbit. I can't do the Elmer Fudd voice. Sal?
Wabbit?
You...
No. I need to practice.
And hare, as shown in various clever episode titles, all refer to Bugs Bunny. While this was likely done to serve the stories, the haphazard interchanging of the different terms probably led many people who grew up with the show to believe that all rabbits are hares and vice versa. In reality, rabbits and hares are different. The common names of some species also contribute to this confusion. Jackrabbits, for instance, are actually hares, whereas rock hares and hispid hares are rabbits. Wow, this is interesting. We are going off rails as of now, by the way, because we are still waiting for more things to be filed and uploaded.
I think we're done for the Friday motions coming in.
Yeah, we're done for the Friday motions. And did you send people over, Kat?
Yeah.
Oh.
Yeah, because my segment was supposed to be for the reading of the one thing, and I was like, okay, well, if we're gonna get the Fani filing, we can read that too. But I just don't think nobody's gonna get that payment portal through on the Odyssey site, and it's not available on the other locations, the other access places. So.
Thank you so much. Now, while I go visit the big boys' room, how about you two promote yourselves?
Okay.
Well, I've got nothing to promote.
No?
No. I'm talking about the Sean Williams trial. Well, the stuff leading up to the trial. His trial is happening now. He's got another trial coming up in a few months. That's all I've got going on.
Nice. Let's see. I have the Rush trial, or the Rush shooting incident. I've got a lot of the discovery body cams, text messages. Thank you, David. I've got the thing I'm thinking of doing tomorrow. I'm going to be streaming tomorrow at 5:30 Eastern. I'm going to be going into the Troy Teskey body cam and all the ammo that was sourced or that was given to the police from Troy Teskey, which ended up getting Alec Baldwin the mistrial with prejudice.
Well, I think the exhibits are really interesting to look at.
Yeah.
And I thought they were interesting before you got the Baldwin texts. I thought seeing all the stuff from Hannah's trial, which I'm sure some of that stuff was still in discovery for Baldwin's parallel trial. But just seeing the way, I don't know. I think the detectives looked at who they wanted to look at.
Yeah.
And they reported what they found because of the way they were looking to the prosecution's office. And the prosecution chose to prosecute what kind of came their way. And that sucks for Hannah, because I do think that 2 other people should have had some culpability.
At least been looked at, yeah.
Sarah and Seth.
Yeah, they're very sus.
Are you watching Ashley Benefield?
Yeah.
Are you following that?
Yeah, are you?
I didn't really get to watch today.
Oh,
but I know they had her reenact the shooting. Guys, if you in the chat, if you guys have watched the Black Swan trial, what are you guys thinking about that? Because people are torn on that too. People have really polarized opinions on her innocence or guilt.
Yeah, I'll just say that, one, it's not a good idea to have a defendant reenact something usually. And then seeing her there just sobbing hysterically. More people, I think a lot more people felt bad for her than believed it.
I watched that over at Broken Bakers. That was not a good choice by the prosecutor, because there might have been a few people on the fence, because it's a bit divided. Is she acting or isn't she? But that was a horrible decision to have her reenact the attack
while sobbing.
Yeah, while sobbing. If And I have 4 sisters who refuses to allow me to protect them in any way, shape, or form, unless it gets really bad.
Yeah.
Then I'm a good person to turn to. I went into kind of a mode watching that. I went into a protective mode
Yeah.
automatically. I'm not
Yep.
sure if she's telling all the truth, but that was horrible.
Yeah.
That was really, really horrible. That was a bad choice from the prosecution. I don't know what she expected to get out of it.
Yeah.
I think part of it is they've been letting this theory fly that he was shot in the back. And now
Oh.
apparently he was shot while like kind of turned sideways.
Oh.
Yeah, but that's a defensive stance in that taekwondo bullshit, that fake kwando. Apparently, that he taught his daughter, and that she was taught in that taekwondo class that try to defuse the situation or try to remove the weapon, which is an almost guarantee to get you killed, by the way. Whoever is on that specific dojo, the taekwondo training place, as the daughter of Mr. What's-his-face, don't go there. That teaching will get you killed. You have 2 things when faced with a weapon. Run.
Yeah.
And run faster. Because while faced with unless your back is literally against the wall, running is, no matter which martial art you claim to profess to, if the first lesson in face of actual danger isn't run, you're at the wrong place.
And probably run zigzag too if bullets are coming at you.
Yeah.
Yeah, and I just don't imagine most people know how to actually disarm somebody in a moving scenario where it's not a trainer kind of positioned and preparing for, the emotions, the adrenaline isn't really there in a training scenario.
No, yeah.
But there were recordings where she was like hysterical in the background. So my take with that is some people are hysterical even when they're the ones that are in the wrong, right?
Yeah.
That's just generally speaking. There are some people that cry because they don't want to argue and they don't want to be called out for things. If the prosecution thinks that she's lying but knows she can cry, those tears, that crying, that demeanor can look very credible even if you believe that person's lying. So if you know that she can turn on waterworks, if that's how the prosecution feels, strategically, why would you put her in a scenario to reenact something that, honestly, even if she is guilty and it wasn't justified, you're eliciting a very traumatic moment nevertheless.
Yeah.
So those tears could be coming out whether or not it was self-defense in the moment or it was something that she did and thought she wanted to do but then regretted after. But that's still going to be a real reaction. You're going to bring back that same reaction.
Yeah.
And as a prosecutor, why would you do that? So I have to watch it. I got to see the clips, and I've seen the other days where I heard the recordings of her having really emotional reactions. I heard the recordings of her.
Yeah,
and it just seemed like piss poor strategy.
Yeah. And I've been watching the Jodi Arias trial, and clearly Jodi Arias not only did it, she planned to do it and
relished in it.
Yeah. She still produced actual tears when faced with the photos.
Yeah.
Well, that's scary. And that doesn't mean I think Ashley Benefield is doing that necessarily by any means. With Jodi Arias, I think she was relishing in everything that she was accused of. I really do. I really, really do.
But
Ashley, I don't necessarily think that.
Sal, don't be so.
Is Sal gonna fix somebody?
Oh, I'm gonna fix Jodi.
You know, Jodi Arias has a wealth of several $1 million.
She does?
Because she's selling a lot of artwork and everything. And this is when she was convicted. I think the amount of money she had to pay the families and everything was less than 50 grand.
Oof.
The rest of what she does, selling artwork and everything, yeah, she has a wealth of millions. Yeah.
Is that a
That-
Jodi Arias piece?
Yeah.
Oh my god!
Yeah, I have one too.
Stop it!
Dave has one too, because we were gifted from
Yeah, somebody sent
somebody
it to me.
Yeah.
I think my difference in reactions is the prosecution was prosecuting Jodi Arias, and I really think there was evidence that she could have stabbed him less times. It was a little bit dramatic, no matter which way you want to look at it.
The
With
prosecutor.
Ashley Benefield, I'm
yeah.
worried that we have a prosecutor that's maybe over prosecuting and could be setting a bad example for how to treat someone that could have a traumatic response, has actually been in a situation where they've been abused. I think the divorce stuff is interesting, and we're still waiting. Did those transcripts come in today from the judge ordered that the transcript from an in-chambers meeting from the divorce proceedings? Because I think that will impact me a lot, but I think there's enough here to say that she's potentially a victim. I don't think beyond a reasonable doubt they've eliminated that factor.
Yeah. Now, when they brought in the text from his ex-wife,
Yeah.
I mean, that's kind of telling. Now, does it tell that he'd continued to do it, or that she copied to have this as her defense? I don't know. But it's weird that in the midst of all this abuse, she paid for his
she put part of it on her debit card or credit card, or reversal of a vasectomy.
Yeah. To get pregnant. And I mean, that's weird. And I don't like weird when it comes to trials. Oh, Jesus Christ.
So you think the suggestion would be a putting it on like a credit card statement to show that she was supportive of the reversal?
Yeah.
Yeah, I can't wait to catch up. I missed a little bit of I have to catch up on the last few hours of yesterday, and I saw bits and pieces of today, but I like watching it chronologically.
Thank you, John Congian. Jodi's back. Jodi's Sledge. She's now a modern day William Wallace. Well, there's a slight difference. William Wallace got his limbs torn from him, while Jodi Arias paints, for instance, Sal's has her back, and Dave has her legs. My painting is of woods. I don't know what that means.
I got her back though.
Yeah, I'll go fetch it so you can see mine.
I need I have like an actual picture of me, but I need like a cool cartoon picture of Cat.
Yeah.
It's my own theme.
My mom.
But I don't know.
Gifted me those two of my cats, like the stepbrothers with my
two
cats.
Yeah, they're very, and like the stoic pose is great.
Yeah.
Like, because they're staring, it seems like they're staring in the direct, even though the portrait is facing at a different angle, it looks like they're staring at your monitor, your camera.
The eyes really do follow you.
They're like coming this way. Yeah, I need some artwork. I just have my little palm tree.
Yeah. It's hard to like design your studio.
I have another area in my house that I want to use, but they've been building a condo. I have one building adjacent to me, and then the street, and then they've been building like it's been so loud all the time, and they start at 7 a.m. here, and they're working until 7 p.m. So all my stuff is not where I like to normally be set up for a year now.
So this is my Jodi Arias print of it's trees and woods. Now, I mean, I grew up in what could be Sweden's Appalachians or something like that. Because, near mountains, woods, lakes, rivers. And for instance, my class in not high school, but say junior high, the year had about 60 people and 5 last names. So people were cousins and second cousins and everything. I mean, that was this is 1,000 years of Scandinavian inbreeding. Let's just say that.
I had a good amount. I moved upstate in New York to high school, and our graduating class was 50, including there was like a separate program that they like brought people in because there was like 8 of them or something close to that number. So they didn't want them to graduate alone, so they combined our graduation ceremonies.
Oh,
So my like high school was really tiny. Really tiny. And they all had Polish last names.
yeah.
With, like CZ in them.
Yeah.
Yeah, like mine.
I was like something ski.
Yeah. Cha.
Well, looking at my name, you might think, oh, that looks like a Polish or Russian name. It's actually a combination of 2 names. From my mother's side, we go way back. We have traced my ancestry to the 12th century.
Jeez.
And on my dad's side, we had a Russian refugee who made himself. He was an archduke or so of some sort, but he kind of pissed off the current Tsar. So Sweden is a good place to swim to. So yeah, it's a combination of that Swedish name and the Russian name. Kate Aiden, Nick, tell us about the helmet, hatchet, and horn on your shelf. Yeah, why not? This is a replica of a 13th century North Germanic chieftain. It is sized to my head. It's I think this is 64, size 64. So yeah, so it's a actual replica of a North Germanic chieftain helmet.
It's pretty awesome.
Yeah. Then I have my hatchet. Stay.
Oh no.
Which is, this hatchet is decorative. And I haven't told this story for a bit, but one of the Nordic Aesir gods who allegedly survives the end of the world, he is the god of justice in peacetime. And so when he sat on his throne, he passed judgment between parties. Now, when he did that, he banged the blunt end. This is my judgment. If you opposed it, he turned to the sharp end. And allegedly, banging the blunt end is where the phrase banging the gavel comes from.
Oh,
So
that's cool.
Yeah. Ghost, I'm 6. No, I'm not 6'6". I am just under 6'4". I'm a big dude, but not that big. I'm not.
He used to play basketball.
No. You couldn't have me in close proximity of. I mean, I played soccer, handball, and other sports, but I always became a goalkeeper because they wanted to keep me away from the
actual
opposing team.
action.
Yeah, because I tend to be sent off. I got a red card on a few occasions, even as a goalkeeper. So they put me in the handball goal, because then at least it's 6 yards between me and the other people. But then the assholes started to jump into my area. And I jumped back at them. And then I was sent off. And if they go into my area, this is my safe zone. I can do what. Apparently, elbowing is not okay as a defense as a goalkeeper. I'm a bit
Depends on the refs.
Depending on the refs. So yeah, I'm a tiny bit competitive when it comes to sport. But I did play in handball in the 2nd division, and at one point I was a substitute for the national team. at
That's cool.
60. That's a 16-year-old.
We have like a handball league. I think there's a bigger one in Orlando, but technically Melbourne, Florida is the metro area near me, even though I think I'm technically closer to certain parts of Orlando. But they have a handball league too, and it's like becoming really big over here.
Yeah, I mean, it's a fun sport to participate in. Not exactly a spectator sport. Unless you have a goalkeeper who uses its elbows. But I was the top goal scorer as a goalkeeper because I could throw the ball across the field. That was interesting because somehow the other team's goalkeeper walked out a bit and then started to listen on their coaches to get, okay, you need to do this, do that, and then shots fired, I saved with either my face or my balls. Because if you ever seen a handball goalkeeper, you do that cross thing. And in my youth, I could actually touch the crossbar with my one foot in the ground and one foot up. I was quite agile back then. But I caught the ball and then threw it back. So I scored 12 goals in one season as a goalkeeper.
That's actually, I feel like that's better than I would do for sure.
I scored more as a goalkeeper than I did as an outfield player. I was just a good wall to put against other. I was always in defense.
Yeah.
Because when something comes at me, I don't move.
You should try hockey, but the hockey players have to do that like weird, like the knees bend inwards so they can block the bottom where the puck's likely to ground its way in.
I tried that too, and they discovered very, very fast that handing me a stick was a bad idea.
They got to put up the shields of glass around you, the protective shields for the audience. They got to put it around you.
Oh, are you getting close? Okay. Come here. No.
I actually really used to like going to hockey games when I was in college because I went to college in upstate New York, so it was like bigger up there. Like all the Canadian players would apply to our schools and like come over the border and play for our teams, I guess. So college hockey was pretty big. It was fun. We used to go to a bunch of different games at different schools. I think it's really fun to watch when you're actually there in person. On TV, I feel like, I don't know, if the camera is like moving right wherever the ball or the puck is, whatever the sport is, I don't like that. I like to be able to see the whole thing.
Yeah. Now you have trying to capture where the ball is going. Bandy or field hockey, that orange little hard thingy. Yeah, that's kind of hard. I don't know if this is a very European sport, bandy. Because it's on the football field, but ice. And then they have this orange golf ball that they try to put in the net of the opposing team. And I think the goal in bandy is a handball goal. So it's not like you can cover down and everything. You actually have to move about. So you can't have that much protection as a goalkeeper. So... And you never see that damn. Oh, and it hurts. Damn, it hurts. Folks, we are approaching the 3-hour mark. Yes. And we have discussed what we needed today. I wish we had more filings to show you all.
I know.
But there simply isn't any. So there's...
Monday Mania.
Yeah, Monday Mania. And I guess that both me and Kat will be prepared to go live at any point in time. If I don't get back to work until too late, Kat, would you mind sending me a link on Monday? Then I can join yours and stream back to my audience.
Yeah, let's do that.
So, yeah, but on Tuesday I have made it clear to the office at 2 p.m. my time. I'm out. I'm gone. I'm out.
Why? Why? To cover a trial in the United States, you know.
I I'm supposed to do that on Wednesday for the Corey Harris update. The guy that was drove into court on his phone on Zoom, but it was going into suspended license. His update is on Wednesday the 7th. And now my boss wants to like have me fly out and record a whole course at a podcast studio for a week-long period. And I'm like, I want to do the Corey Harris update, which is so stupid, but I really want to.
Yeah. Like our real bosses don't understand what we sacrifice.
He's not really even my boss. Like I'm freelance, but I just call them all my bosses because it's easier than explaining my client.
Yeah.
But
I mean, work gets in the way of the fun stuff. I mean, so folks, like, subscribe, and if you have the ability and the means, super chat, gift memberships and stuff like that. On my channel, not necessary. I'm doing okay. But if you want me to, I mean, eventually when we get to, I mean, EDB level kind of subscribers, yeah, sure, this might be a full-time gig.
Yeah.
But until then, we all have daytime work.
Yes.
But so
I would never want that many subscribers. Oh my God.
Oh God, yeah.
I'm kind of fearful. I think around, for instance, Jeff Legal Vices, who I'm going to redirect to, that I believe is almost the top limit of what I want, because I want to look in the chat and recognize people.
Yeah.
I mean,
I really like
looking
that.
at EDB's chat, it just flies. And
I prefer smaller chats when I'm interacting with other streamers.
So I want fewer but much wealthier audience.
We just like to be friends with everyone.
Now, I've discovered that when I cut out different portions to make videos, those kind of, I mean, I get between 500 and 1,500 views, which is all right. But those videos, because my streams has what is the pay per 1,000 views at about $1.20, but my videos are at $4 per 1,000 views in ad revenue.
Yeah.
So, I mean, that's okay for me. I mean, Roland Arthur. No, here's the thing. I will never demand of anyone to send money. If you don't have it, don't send it. If you have something you'd rather spend money on, spend it on that. I'm doing okay, folks. I'm doing okay. Just watch my content, give a thumbs up, subscribe, and
hit the like button.
Yeah,
because the interface has changed, and now the like button ratios are like, because it's hard. You gotta like minimize the whole chat on the side panel now. The likes are a little bit more difficult to get to.
Yeah.
So
figuring out the algorithm.
And same for you over at Rumble that I'm also streaming at. Thumbs up, subscribe. You never know when YouTube decides, we don't want this, and all of a sudden we are yeeted. Then at least we have Rumble. At least the start of a platform on Rumble. So never give what you don't have, folks. Never do that. If you have to choose between beer and me, choose beer.
Well, we'll ask your sponsor first, but
ask you.
Or just don't tell yours. No, I'm kidding. I totally love like the increasing ease of becoming sober. I think there's a lot of companies that are trying to productize sober activities and make money on the new people that no longer drink and need to spend their money on other things. But I think it's really cool that you can go out and order non-alcoholic things, and people aren't assholes to pressure you to keep drinking if you don't want to.
Yeah, I mean, the first non-alcoholic beers were disgusting. Now they're getting the hang of it. I mean, I have a beer that it's called Ship Full of IPA. It's a Swedish brand. Amazing IPA, and it's non-alcoholic.
I don't think anybody has ever said amazing IPA before.
No, people that like IPAs are very loyal to IPAs. Very loyal.
Tease. Oh, thank you so much. And
Haha,
folks,
she's getting you with the spin.
we get a spin on the wheel of regrets. Here it is. Thank you, TST. Thank you so much.
There's
You
a
need
bow in the
regrets.
dog's hair and the dog's fur. Dog hair? Yeah, hair.
So let's
Is there a
before
bow?
I
A cute little bow in her picture?
Aw.
Right? He has a little
Aw.
bow.
Aw. Oh, that's so sweet. So let's end off today's Friday panel. This will be a reoccurring event, the Friday panel show, 6 p.m. Eastern Standard Time, because I like this format where now most of what we've done so far is the Young Thug trial of obvious reasons. That will continue. But if nothing happens in the Young Thug trial, let's talk about other cases. And every guest I have on my panel will be able to stream the same thing on restream, because I don't have that restriction. So, because I believe in sharing. But now,
Spin
to
the
send
wheel.
you all, spin the wheel.
And tell me what does that word mean? And in the ad it says fucked, but it's F-U-K-T. What does that mean?
Hey,
That's an interesting sending
I
off.
feel like I read the ad at the right time.
What ad? What?
Right above it says F-U-K-T, so to me I read that as fucked. And then
Oh.
it gave you habanero sauce. But what does that actually mean if you translate it to English?
That is
F-U-K-T.
moist mole sanitation. So yeah.
I'll never need to know how to say that, ever.
Yes, but F-U-K-T in the Swedish word fukt is moist.
Moist is fukt.
Where's
My
my
German
habanero
grandmother would be
sauce?
so proud.
Oh my gosh.
Here is my habanero sauce.
Enjoy.
Oh my god, cute. The dog had a backpack.
Yum.
You gotta shake it. It looks up. Yeah, there you go.
There you go. Yeah,
I'm not
goodness.
doing the mistake as I did a couple of months ago. I forgot to put the cork on and then started shaking it. That was a bad idea.
The room became fooked.
Do the whole bottle.
Nom 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 nom.
The first cop.
I love
It's
the
so
hiccups.
cute.
Oh
Traveling.
no, up the nose. No.
Oh, these hiccups.
Oh.
The nasal cavity is fooked.
His colon is spooked.
That's because you're wearing the fiery blazer. Your hiccups are making me need to drink water. Yeah, we learn new words here, guys.
Oh, but it went up my nose for some odd reason as well.
You're handling it way better than I would. I'd be like, bye guys, gotta go.
I ate 2 habaneros on a dare when I was 16, and I ran through the grocery store trying to find anything to like quench the burn, and then threw up.
Yeah,
in the grocery store.
No, in the parking lot. I got out of the grocery store, but it was not pretty.
That sounds horrible. Puking up habanero.
I certainly relived it.
Maybe better in that direction.
Probably.
I ate the Dorito challenge chip. I would not recommend that to anybody. The
Ooh,
Taki, I don't know what it was called. The
Oh.
Taki chip. My stomach hurt so bad.
Yeah.
Like I really thought I was going to die. My stomach itself, like it felt like my stomach lining was just like, why would you do this to us? And just started attacking me.
Now I'm just glad it didn't stop on the Inferno, because this is 50% scorpion, yellow scorpion, Moruga scorpion chili. That is one of the super strong ones. Wow. Okay, I need to blow my nose. Okay, but we are way past the 3-hour mark. I'm going to send you over to Jeff Legal Vices. I will join there. Have you got an invitation, Kat?
Yeah, I'm gonna pop in after I go make something to eat.
And I will send Sal one too, because surprise.
No, it's okay. I'm going to bed. So
okay, yeah, you have work tomorrow.
Yeah.
Okay, thank you everybody for showing up. Thank you guys for allowing me to do this, to try to decipher this clusterfuck that is the Young Thug trial. And I will see you tomorrow at the Yodi Aries. We have entered the prosecution's closing statements, the final half hour. Then we will start the defense closing statements.
Defend my bay.
What's up tomorrow? So everybody, thank you so much again, and hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Okay? See you tomorrow or over at Jeff's. See you.
Bye.
Bye-bye.
I say I run from the hall in the courtroom, so I'm still will fall in my battle lines. I'll expose as a stain, breaking lawyer. I won't accept defeat. Justice tremble as I enter the room. Corrupt prosecutors need them too. I'll fight for justice with all my might. In the name of honor, we'll make things right. No more secrets hidden in the dark. I'll bring justice with the thunder and stars. With my feeling across